Without objection, the chair is authorized to declare a recess of the committee at any point. Pursuant to Committee Rule 3 and House Rule 11, the chair may postpone further proceedings today on any vote relating to any matter under consideration during today's markup. As a reminder, all members on the WebEx platform should keep themselves muted and should only unmute themselves when they are recognized. The staff have been instructed not to mute members except when a member is not being recognized and there is inadvertent background noise. Members on the WebEx platform are also reminded that they may only participate in one remote proceeding at a time. So if you're participating today, please keep your camera on, and if you choose to attend a different remote proceeding, please turn your camera off. Members seeking recognition are encouraged to identify themselves by name to facilitate recognition and to ensure cameras are redirected accordingly. For members who are participating in person, wearing a mask at all times while in the hearing room is a requirement, including while speaking into a microphone when recognized. This is based on guidance from the Office of the Attending Physician, and the chair will treat wearing masks as a matter of order and decorum. Members who do not wish to wear masks may participate virtually through the WebEx platform. We will be collecting and distributing amendments electronically to ensure all members have equal access to relevant documents in this hybrid format. Members who are participating in person are encouraged to have their own devices with them to access the amendments electronically. All amendments must be submitted to the committee email provided in the meeting notice. The amendment will then be given a unique identifier for reference and distributed to all members through an email list that was developed in advance in coordination with the ranking member. As is the chair's practice, amendments that are pre-filed will be given priority consideration. While we're trying to make this process as familiar as we can, we must recognize the limitations that go with ensuring the safety of all members. So I ask for members to be patient with delays and other limitations we face in this hybrid format. Without objection, all members will have 5 legislative days within which to revise and extend their remarks and to submit additional materials to the chair for inclusion in the record. I now recognize myself for 5 minutes for opening remarks. Today, this committee will mark up 6 bills. As chairwoman of this committee, I'm very pleased to advance several strong legislative solutions that have been introduced by committee Democrats. At this markup, the committee will consider a number of bills, continuing with the committee's ongoing work to advance racial and gender equity and provide fairness for LGBTQ plus persons, including the Fair Lending for All Act, H.R. 166, a groundbreaking bill by Representative Green that will help combat discrimination in the consumer financial marketplace, including on the basis of sexual orientation and gender identity. This would be done through updates to the Equal Credit Opportunity Act and Home Mortgage Disclosure Act, and through the creation of a CFPB Office of Fair Lending Testing that would incorporate techniques used successfully by researchers to better identify and address discrimination in financial services. We will also consider the LGBTQ Business Equal Credit Enforcement and Investment Act, H.R. 1443, a bill by Representative Torres that would clarify and update Section 1071 of Dodd-Frank to ensure that lending data with respect to LGBTQ-owned businesses are collected along with small women-owned and minority-owned businesses. Transparency is key to cracking down on discrimination in the financial marketplace. Today, we will also mark up the Improving Language Access in Mortgage Servicing Act, H.R. 3009, a bill by Representative Sylvia Garcia. This bill would help close information gaps and prevent foreclosures by ensuring that people with limited English proficiency have access to documents and services in their preferred language. At this markup, we will also consider a number of bills to improve and enhance corporate disclosures and provide investors with material information, including the Greater Accountability and Pay Act, H.R. 1188, a bill by Representative Velázquez, which would enhance accountability for corporations with regard to pay disparities by requiring certain public companies to publicly report information on executive and employee pay raises. The Climate Risk Disclosure Act, H.R. 2570, a bill by Representative Casten, which would require public companies to disclose the risk they face due to climate change, and the Disclosure of Tax Havens and Offshoring Act, H.R. 3007, a bill by Representative Axne, which would require public companies to disclose the amounts they have paid in state, federal, and foreign taxes and the profits before taxes to provide investors information related to the tax liability of public companies and whether those companies are supporting the U.S. economy. So I would like to thank the members for their work on these important bills and look forward to passing them through the committee. I now recognize the ranking member, Mr. McHenry, for 5 minutes for any opening remarks he may have.
Well, thank you, Madam Chair. Let me start with 3 quotes. April's expected hiring boom goes bust. U.S. economy added just 266,000 jobs last month versus estimates for 1 million or higher. And major disappointment, America added way fewer jobs than expected in April. Those are the headlines. These are just a few of the headlines since last week's shocking jobs report. To be clear, the shock is warranted, but let's get past the headlines and dig deeper into the data. The fact is the economy created 597,000 new jobs in March, but we could only fill 266,000 of them in April. The National Federation of Independent Businesses reported that 42% of business owners had job openings that could not be filled, a record high. Yesterday, the Bureau of Labor Statistics reported the job openings level reached a series high of 8.1 million jobs available. That is positive, quite positive, and it shows that we're coming out of the COVID shutdown economy. But why can't we fill these jobs? We know vaccines are widely available and businesses are lifting capacity restrictions and safely reopening. We see that here in the District of Columbia's government and when they're lifting these opening restrictions. This should be a recipe for a hiring rebound. It should also be a recipe for Congress getting back to normal business. So why does the reality not reflect the data? The truth is there's something else at play, even if the Biden administration won't say it. It's the Democrats' policies that are stalling our recovery. President Biden's partisan $2 trillion so-called COVID relief package has made it more appealing for Americans to stay home instead of going back to work. Consider this, the job filling rate is at an all-time low. In fact, there were fewer hires per job opening in March than at any time since they started collecting this data. This can't be blamed solely on COVID. Over the last 20 years, our country has faced a financial crisis, a great recession, and we still had better hires per job opening during those times. We also have a devastating number of women not returning to the workforce because our schools are not fully reopened. We know child care is a requirement for both parents. It is. And we're seeing a lack of child care and a lack of reopening of our schools restricting job growth and job opportunities. And we know that the science says that we could have safely reopened schools months ago. We also see lows in the retail and service sector, which should be booming as the industry rapidly reopens. Instead, we see a sluggish recovery directly caused by Democrats' policies. We should fix this. So maybe before we consider adding additional progressive priorities, we should address the issues caused by the first set of Democrat proposals. Regardless of the facts today, we'll mark up 6 Democrat bills that are focused on more government, more regulations, more disclosures, more expense, more of the same old policy solutions that we've come to expect from our progressive friends on the left. Not one bill on the agenda today will help small businesses access capital, help investors save for retirement, or help them save for their children's college education, or help them build a better life. Not one bill will create jobs, help a family buy a home, or contribute to our economic recovery. Just look at H.R. 1188, the so-called Greater Accountability and Pay Act. That's what my colleagues, what my colleagues won't tell you about this is that Dodd-Frank already requires public companies to disclose the ratio of its CEO compensation to the median compensation of its employees. Yet apparently this mandatory disclosure isn't enough. Now they want companies to disclose the pay raise percentage of its executives and the pay raise percentage of its median employee over the past year and compare each to the rate of inflation. They also want public companies to disclose the ratio between the 2 pay raise percentages. A lot of math there, got it. Never mind, a company's pay ratio is a unique calculation based off that company's custom methodology and unique compensation structure and composition of their employees. Never mind, this ratio is meaningless as a comparative metric. You can't compare one company to another. The intent is clear. Let's name and shame public companies, and that feeds back into progressive policy goals. I could go on about the rest of the bills and the markup today, but I can summarize it in one sentence. More government, more regulations, more bad policy that will yield bad outcomes. I yield back.
Thank you, Ranking Member McHenry. At this point, I would recognize Ranking Member McHenry for a brief point of personal privilege.
Well, thank you, Madam Chair. And we know that on Capitol Hill, the staff makes this place work. And we know that we have patriotic Americans that want to come and serve in this place, not just as members of both parties, out of love of our country and hope for a better future, but our staff has that same motivation. And so I want to recognize a member of our committee staff who's heading off the Hill. Frankly, he's going to go work at a startup, which is, if anybody's ever met him, you would think that that's where he works anyway. That's Matt Mulder. And so we call him Mulder. His friends call him Mulder. And he was a member of my personal staff, the committee staff before, and then he came back to my personal staff and is now the deputy staff director here on the Financial Service Committee Republican staff. And he's been our resident crypto expert on cryptocurrency. And like many staffers, Mulder came to Capitol Hill as an intern. He was a rare intern because he already had a decade of legal experience, but he really wanted to come work on Capitol Hill, and he's willing to come as an intern to get some experience. And while he loves the politics, the Hill was calling, and he really wanted to be here. So from the start, Mulder has contributed a unique set of skills to each position he's held. So much so that we actually developed a term for what he does, which is moldering. Moldering on something is what we'll say, right? Well, we need a molder on that. Or can we get molders to sort of do his moldering on that? Well, the whole idea is it's a pretty common phrase that we use, and it just generally means pondering, thinking, or generally ruminating on a topic. Most likely cryptocurrency or something we have not dealt with in the committee before, a new idea, a new challenge, or whatever else. We'll have him molder on it. But frankly, it could be something that fancy, or it could be just a new fashion trend that he has deep thoughts on. But in all seriousness, Matt is a critical thinker, outside the box problem solver. He's been a dear friend to me, close confidant and advisor and counsel. He will be sorely missed by me personally, but also by his committee staff colleagues on both sides of the aisle. And he's been a tireless advocate for innovation, technology, and whatever's kind of cool and new. And so, Matt, we miss you. We miss you in person, but we will miss you being able to work with you on a daily basis. But we want to wish you, Kat, and your 3 kids all the best in this new world that you're endeavoring in. So with that, thank you, Madam Chair, for a point of personal privilege, and I'm grateful for Matt's advice and counsel and friendship, and very grateful for our committee staff on both sides of the aisle that love our country just as much as anyone and want the best outcomes. Even if from time to time we may have disagreements here, we all love our country and want it to be a better place. So with that, thank you, Madam Chair.
Thank you, Mr. McHenry. I also want to wish Mac well. He's long been a strong advocate for innovating our capital markets, some may say recklessly. He has worked closely with my staff on creating bipartisan legislation on crowdfunding, and then again, when we had to fix what the Senate did to our best efforts. While we may not always see eye to eye on policy, I respect that he is both principled and knows when and how to reach a compromise. Good luck in your future endeavors. Thank you very much for your service.
Thank you, Madam Chair. Madam Chair, can I inquire a parliamentary inquiry on the schedule for today?
Gentleman is recognized for a parliamentary inquiry.
Madam Chair, for planning purposes for member schedule, both virtually here in person, what is the chair's intention on how to go about the work today, and the order of business or when we're going to vote would be helpful.
I don't.
But it will depend on the time.
So what?
Hopefully we can reschedule to
Moldering on it.
but we don't know how
We
long.
could, we don't know how long we're
Like,
going
the
to.
goal would be,
Yes.
we would like to finish today. We would like to finish by 6 o'clock, because there is a classified brief.
Okay. Okay, Mr. McHenry.
Yes, ma'am.
In conferring with the
Sure.
staff and trying to anticipate, the amendments, et cetera, we believe we can finish today. If not, I would rather we could finish by 6 o'clock this evening.
And is the intention to roll votes to the morning or do it as soon as we finish the work today?
Ideally today.
Today,
Ideally.
today.
All right, thank you, Madam Chair. I yield back.
Thank you very much. Pursuant to notice, the chair now calls up HR 166, the Fair Lending for All Act. The clerk will report the bill.
HR 166, a bill to establish an Office of Fair Lending Testing to test for compliance with the Equal Credit Opportunity Act, to strengthen the Equal Credit
Chair, I ask
Opportunity
that the bill
Act
be
and to
considered
provide
read.
for criminal penalties for violating such act.
Without objection, the first reading of HR 166 is dispensed with. The gentleman from Texas, Mr. Green, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and are also on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to HR 166 offered by Mr. Green of Texas. Strike all after the enacting clause and insert the following. Section 1, short title.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentleman from Texas for 5 minutes to explain the bill and his amendment.
Thank you very much, Madam Chair. Madam Chair, I'm grateful to you for allowing this bill to come to the attention of the committee. I'm also grateful to the staff for working with us on this piece of legislation. This legislation is one that has taken us years to bring to fruition. The staff has done an outstanding job, and I'm most appreciative. Madam Chair, the Equal Credit Opportunity Act exists because equal credit opportunity does not exist. And this bill seeks to cure some of the concerns related to the lack of equal credit opportunity. I am going to announce at this time that this bill is widely supported. Over 40 national and local organizations are in support of the bill. This would include organizations such as the Center for Responsible Lending, the Leadership Conference on Civil and Human Rights, the NAACP, the NAACP Legal Defense Fund, the National Fair Housing Alliance, and many others. This bill, H.R. 166, would provide critical tools for detecting, ending, and sanctioning discrimination that would otherwise go undetected and that every day perpetuates race-based differences in wealth, asset accumulation, income, and financial security. This is why H.R. 166 is a bill that creates an office to conduct testing so as to give us an opportunity to use it as a tool, an enforcement tool, to determine whether or not invidious discrimination exists in lending. H.R. 166 will expand ECOA's terms to expressly prohibit lending discrimination against LGBTQ persons. And today, in our country, under ECOA, nothing prevents a lending officer from denying a mortgage to an applicant solely because the person happens to be gender nonconforming or non-binary. Finally, H.R. 166 would establish criminal penalties for lenders and lending officials who engage in knowing and willful discrimination in violation of ECOA. The penalties would include for an individual up to $50,000 in fines and 1 year in prison. If there is a pattern or practice, $100,000 and imprisonment not to exceed 20 years. There may be some who would conclude that these penalties are to be thought of as something that might be excessive, but I would remind us that under 18 USC Code, Section 1344, which is styled bank fraud, this deals with persons who knowingly execute or attempt to execute a scheme or artifice to defraud a financial institution, some lender, to obtain any monies, funds, credits, assets, securities, or other property owned by or under the custody control of a financial institution. And if you do this by means of false or fraudulent pretenses, representations, or promises, that person shall be fined not more than $1 million or imprisoned not more than 30 years or both. This is the law as it relates to those who would attempt to defraud a lender. I believe that this is appropriate for lenders who would defraud those who have qualified for loans and are being denied loans. Let me say this. I was here at the downturn of the economy in 2008, and I can recall what happened with the yield spread premium. We had many persons who were denied loans not because they weren't qualified. As a matter of fact, they received loans that they were qualified to receive, but they were in higher interest rates than they actually qualified for. A quick example, you could qualify for a loan at an interest rate of, say, 5%, but then the loan officer would come out and say to you, great news, you just qualified for a loan at 8%. And that spread would be something shared by the originator and the lender. This was something that occurred quite often with African Americans. In fact, one bank had a settlement for some $335 million as a result of penalties that were imposed. And there were some 200,000 identified African American victims. This was one of the largest settlements in history. So I think that this bill is needed, and it will help us to cure and close the wealth gap to some extent.
Thank you, the gentleman. Our ranking member, Mr. McHenry, is recognized for 5 minutes. To strike the last word.
Well, thank you, Madam Chair. And first, let me say that discrimination has no place in our society. We have to come together to root out all forms of discrimination. This includes in lending. However, expanding the CFPB and creating more regulatory chaos will not protect borrowers, nor will it protect lenders. It will not make matters better. It will, in fact, make matters worse. That's exactly what this bill does. It will create more regulatory chaos. It creates more regulation, yes. More uncertainty, though. It expands the role of the CFPB, which is already deemed an unconstitutionally structured agency. Now, that's not my opinion. That is the Supreme Court's opinion from the case and their opinion written last June. So the CFPB is a an unconstitutionally structured agency. But once again, this bill vests broad powers in that one individual, the head of the CFPB, to police discrimination in the financial sector. In fact, the creation of this new office is authorized to conduct undercover investigations of lending practices and making recommendations directly to the Attorney General. This doubles down on the unconstitutional structure of the CFPB, and in fact goes beyond what has traditionally been given to the CFPB in powers. This bill is a throwaway to trial lawyers as well, expanding both the population of individuals who can sue under ACOA, as well as the individuals who may be held liable for ACOA violations. There is no attempt at achieving a bipartisan result here, and so what we have here is a bill that will create uncertainty in the credit market, driving up costs for all borrowers and potentially excluding the borrowers who need it most, those on the margins. So, sadly, we have to oppose this bill. I think we need to give lenders certainty. I think we need to give borrowers certainty. This bill does not do that. It makes matters worse, not better. I understand the author's intention here, certainly understand it, and his intentions are quite good at rooting out discrimination. The form of this bill, though, is not the way that we can achieve a bipartisan result here. Empowering this Bureau to even be more unaccountable and doubling down on the unconstitutional structure is of core concern. And so I think we need clear rules of the road, and we need to enforce them clearly. So I'll end where I started. Discrimination has no place in society. We should work together to eradicate all forms from society. Expanding the CFPB is not the right step to do that. I yield back.
The gentleman from Georgia, Mr. Scott, is recognized for 5 minutes to strike the last word.
Thank you. Thank you very much, Madam Chair Lady. You know, I was listening to our distinguished ranking member, and I couldn't disagree with him more. If ever there was a time when we could see the impact of discrimination and racial prejudice in our country, it is now. And within the financial fabric, which is how we exist, it has long been established the discriminatory lending practice that have been in there. You're familiar with redlining. We're still fighting that. And so, with all respect, as the ranking member knows, we're good friends, we work together, but I take quite homage with his comments because the American people see very vividly the damage that entrenched and discriminatory policies impose on our communities, and especially the African American communities. There are others, but there is no pointed discrimination to match that, which historically has fallen on African Americans. So Mr. Green's bill, and I want to point this out to our ranking member. Mr. Green bill simply takes essential steps to make sure that no borrower, regardless of race, creed, or color, is denied credit based on who they are or where they live. And as I said, we need this to be a wake-up call to our financial lending industry, that we see vividly the damage that entrenched discrimination policies have on our people in this great country. And so with that, Madam Chair Lady, I just urge all of our members, both on the Democratic and the Republican side, to do this, pass Green's bill bipartisanly for the good of our great nation at this important time when we need healing.
Thank you. The gentleman yields. The gentleman from Arkansas, Mr. Hill, is recognized for 5 minutes.
Move to strike the last
The
word.
last word.
Thank you, Madam Chair, and I want to thank my good friend from Houston for his constructive bill to bring attention to and additional strength to the idea of eliminating discrimination in lending in our country. This is something that's important. It's something that every financial institution takes very seriously under existing law and existing regulation, overwhelmingly. In fact, I think it's disproportionately on the minds of every lending organization in the country that's regulated for home mortgage disclosure purposes, for fair credit reporting purposes, for fair lending. And those great statutes passed long ago now, over 4 decades ago, have the real strength of civil and criminal penalties. And again, let me say, as someone who's worked in the financial services industry, lending officers, credit committees, boards of directors, CRA, community reinvestment officers, all have this at front of mind on a daily basis, because as the ranking member said, there's no place in our society for discriminating in credit or any other way in our society. And so I want to thank my friend Mr. Green for bringing through his well-intentioned and crafted bill. And in fact, for the 6 years I've served in the House, he's consistently over those 6 years asked this question about fair lending testing. And in the financial services industry, it goes by many different names. In our company, we called it secret shopping, because that's what retailers call it, where you check the performance of your employees against a customer service metric and a legal regulatory metric that's required. So it's both that personal customer service, that every person is treated just the way you'd like to be treated, and is it compliant with federal law? And I'd say to my friend that most businesses in financial services, large and small, particularly in commercial banking, consumer banking, perform that task now as a part of their independent audit standards to make sure that their employees are well trained and they're treating all customers in an equal, fair, and appropriate manner. And those audit results, those internal audit results, are part of the internal audit work papers that our regulatory bodies look at during exams. And on top of that, the regulatory bodies themselves do that kind of secret shopping, if I can use that term. So when my friend from Texas has asked that question of both private sector financial folks that have come before this committee and our regulatory agency heads, they always say, well, of course, because it's a regular activity that's undergoing now. So with all that said, I appreciate his efforts, but in my view, I think that we are adequately demanding, checking, performing, and back-checking this internal audit standard to be compliant with fair lending across our country, and belt and suspenders on that, both in the private sector and through the existing regulatory system. So personally, I don't believe that this idea of creating a separately charged person at the CFPB to do this is necessary inside our financial system, which doesn't take anything away from the gentleman's passion on this issue, which I share, and I think is dealt with on a daily basis in both the regulatory system and the public sector regulators that we charge to enforce these important fair lending laws. So reluctantly, I have to oppose this bill as being more than we need at this time, and that I think it's many redundant to the existing systems that are working to check those pernicious impacts of anyone who's making a mistake by not being a fair lender. To my friend, Mr. Scott from Georgia, I share his concern over this issue, but I think it is being addressed aggressively both in the private sector and in the existing regulatory system, and I yield back the balance of my time.
Thank you. The gentlewoman from Ohio, Ms. Beatty, is recognized for 5 minutes to strike the last word.
Thank you so much, Madam Chairman. Move to strike the last words. To Chairman Green, let the record show that I strongly support HR 166, the Fair Lending for All Act. Let me make a few brief comments. As someone who has worked in housing, someone who's a small business owner, oh, how I wish those words, no place for discrimination in our society, could ring true. We all know that there is systemic racism. We all know that there is injustice, and it is that we don't have fair lending practices that are upheld. We've talked about the Constitution and the courts. So let me just briefly say, the courts have recognized 3 methods of proof of lending discrimination: overt evidence of disparate treatment, comparative evidence of disparate treatment, and evidence of disparate impact. I can say to you one word: redlining. Many of us have lived through it. I just finished a committee on joint economic where we're talking about some of the same issues. We know that we are still in the headwinds of systemic racism because of the disparities for women and people of color who are denied access to credit at a disproportionately higher rate than white male consumers. And we know when they don't obtain credit, often they pay higher fees and they are offered fewer products. We heard during the 116th Congress, the subcommittee on D&I, we received testimony after testimony from witnesses highlighting the persistent discrimination in lending that is faced by women and people of color and all those other things that they are not able to get. I wish we lived in a fair world. And then I could agree with my last 2 Republican colleagues. But we can look to our chambers, we can look to this committee in statements and things that we hear, and data and fact after fact will tell us that we need to protect our consumers. We know that we still live in a world of inequalities. Women make less on the dollar than their male counterparts. We know that when we go to buy a house, and I'm telling you what I know, I watched my father walk in to try to get a loan to buy a house. And then I watched a white minister go in with the same information and the same facts that my father had shared, and he was able to get the loan for the house. And then they stood together and shared that information. Discrimination clearly exists, but I think it is so important for us to support this bill, because when you think of what this bill is asking for, it is asking us to eliminate the persistent discrimination. It's asking us to hold ourselves accountable for better performance. in lending. How could we say this is an overreach? How could we literally say that we believe that discrimination does not exist? So I have a hard time accepting the comments from my two previous colleagues. I want to believe that they know better. So I'm hoping that they will vote better and support this bill. And I yield back.
Thank you very much. I now recognize myself for 5 minutes. I do believe that we have Mr. Cleaver, who is recognized for 5 minutes to strike the last word first. Thank you.
Move strike the last word. Madam Chair, let me first of all just mention that because I think Missourians are always proud of Harry Truman. Our only president, I guess, came close in '72 with McGovern and Tom Eagleton, known as the 18-day running mate. But Harry Truman had said so much that we quote today, but one of the things he said was, I think it's going to be around forever. He said, it's amazing what you can accomplish if you do not care who gets the credit. And I've modified that a little, and I'm going to say it this way. It is amazing what you can abolish if you don't arbitrate those who determine how you get the credit. And I want to, at the same time, compliment my longtime friend, Mr. Green, and I applaud his leadership in advancing the Fair Lending for All amendment, which would create a very important Office of Fair Lending Testing with the Consumer Financial Protection Bureau and additional protections for LGBTQ plus persons, and create criminal penalties for violations of the ECOA. And at this time, I would yield to my friend, Mr. Green, such time as he may consume.
Thank you, Mr. Cleaver. I greatly appreciate it. And to my friends, Mr. Hill and Mr. McHenry, the financial institutions have in place not only civil remedies, they also have criminal remedies. In fact, I mentioned the fact that you can be fined not more than $1 million or imprisoned not more than 30 years or both if you try to defraud the bank, if you go in and you give false information in your own application. So the banks are well protected. This piece of legislation provides similar protection for consumers by giving consumers a remedy that goes beyond the civil penalties. There are criminal penalties associated with this legislation. That acts as a deterrent. I would also remind my friends that while we conclude that there are remedies that are sufficient, we don't really know because we don't have the empirical evidence to support the conclusions. The testing is the best means by which we can acquire the empirical evidence necessary to prove or disprove your proposition. But in every case with rare exceptions, when testing has been done, we have found that invidious discrimination exists. The empirical evidence points to discrimination. It does not eliminate discrimination, not the empirical evidence. So we need this additional deterrent. The banks have it. $1 million if you attempt to defraud the bank, up to. And then you've got prison time if you attempt to defraud the bank. This is for consumers. There is a Consumer Financial Protection Bureau, not just a Financial Protection Bureau. Let's make sure that consumers have a fair opportunity to access credit. In this country, credit is the means by which most people have the opportunity to amass their wealth. If you can't access credit, you're not going to have the bootstraps that we so often conclude we should pull ourselves up by. You have to have the credit. That's where the bootstraps are. And very, very often, persons of color, minority people, LGBTQ, these persons cannot get the same credit that others are getting. And it really is bigger than we would like to pretend it is sometimes. And I'm not saying my two friends are pretending, but I am saying that many people do. I believe that this bill, its time has come. We've been working on it for years. I'm appreciative for all who have helped us to bring it to fruition. And with 40+ national organizations and local organizations supporting it, I believe that we should pass it. And I'm grateful to you, Madam Chair, for the additional time, and I yield back to Mr. Cleaver.
Thank you very much. I now recognize myself for 5 minutes. H.R. 166, the Fair Lending Act for All, offered by Representative Green, would certainly clarify that the Equal Credit Opportunity Act prohibits credit discrimination on the basis of sexual orientation and gender identity and expands the law to prohibit discrimination on the basis of zip code and census tract. The bill also expands the disaggregation of data collected under the Home Mortgage Disclosure Act, providing an important tool in uncovering and eliminating discrimination. Congress passed the Equal Credit Opportunity Act and Home Mortgage Disclosure Act to address patterns of discrimination in the consumer financial marketplace. These clarifications and additions to fair lending law will allow for more robust enforcement after significant declines during the Trump administration. The bill would additionally create the Office of Fair Lending Testing in the Consumer Financial Protection Bureau to test creditors' compliance with the Equal Credit Opportunity Act. Testing methods like paired testing or civil rights enforcement tools that have been used since at least the 1960s to unearth patterns of individual and systemic discrimination. For example, entities like the Department of Housing and Urban Development have used match pair testing to uncover illegal and unequal treatment in the housing market. Mr. Green's bill would allow the CFPB to use testing to reveal and penalize knowing or willful discrimination by lenders that would otherwise remain hidden. H.R. 166 is supported by a number of national consumer and civil rights groups, including the Center for Responsible Lending, the NAACP, and the National Coalition for Asian Pacific American Community Development, as well as many state and local organizations. So I certainly urge all members to support this very important bill. And with that, I yield back the balance of my time. Is there further discussion of or amendments to H.R. 166? If not, the question now occurs on approving the amendment in the nature of a substitute. All those in favor say aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering H.R. 166 as amended to be reported favorably to the House. All those in favor say aye. Aye. Aye.
Aye.
Those opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The ayes have it, and H.R. 166 is agreed to.
Ask for a recorded vote.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered. Pursuant to Section C5 of Committee Rule 3, the vote on this question is postponed. Pursuant to notice, the chair now calls up H.R. 1443, the LGBTQ Business Equal Credit Enforcement and Investment Act. The clerk will report the bill.
H.R. 1443, a bill to amend the Equal Credit Opportunity Act to require the collection of small business loan data related to LGBTQ-owned businesses.
Without objection, the first reading of H.R. 1443 is dispensed with. The gentleman from New York, Mr. Torres, The sponsor of the bill has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and are also on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 1443, offered by Mr. Torres of New York. Strike all after the enacting clause and insert the following. Section 1, short.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize a gentleman from New York for 5 minutes to explain the bill and his amendment.
Thank you, Madam Chair. In the United States, there are 1.4 million LGBTQ businesses, contributing more than $1.7 trillion to the American economy. We have a vested interest in sustaining and strengthening these businesses with equal access to credit, which is the beating heart of the American economy. As a former New York City Council member, I partnered with the National LGBTQ Chamber of Commerce to establish the nation's largest municipal certification program for LGBTQ business enterprises, enabling those businesses to enjoy equal access to a $25 billion pool of government procurement. The legislation before us, H.R. 1443, builds on a foundation laid by several statutes and regulations. The Equal Credit Opportunity Act prohibits credit discrimination, including but not limited to sex discrimination. A new interpretive rule from the Consumer Financial Protection Bureau clarifies that ACOA's prohibition against sex discrimination applies to sexual orientation and gender identity. Section 1071 of Dodd-Frank, which exists to enable and enhance the enforcement of ACOA, requires financial institutions to report information about the race, ethnicity, and sex of credit applicants who serve as the principal owners of small businesses. My legislation would expand the 1071 reporting requirements to include not only sex, but also sexual orientation and gender identity. In doing so, it would enable anti-discrimination enforcement where none might exist. Even though in the United States has made substantial strides toward LGBTQ equality, the mission is far from accomplished. 70% of the LGBTQ community remains unprotected by anti-discrimination laws. When it comes to credit in particular, according to the Williams Institute, more than 7.7 million LGBTQ adults live in states that offer no protection against discrimination based on sexual orientation or gender identity. It is often said that knowledge is power. Knowledge affords us the power to detect discrimination that might otherwise go undetected. Take as an example the Home Mortgage Disclosure Act, which is analogous to the legislation before us. Both the National Community Reinvestment Coalition and the Iowa State University reviewed data from the HMDA and found that same-sex couples were denied loans at higher rates than heterosexual couples, despite having comparable creditworthiness. It also found that these same-sex couples paid higher fees and interest rates. The experience of the HMDA tells us that sunlight can be a powerful disinfectant against discrimination. H.R. 1443 would make credit more accessible, credit laws more enforceable, and creditors more accountable. It would represent a triumph of transparency in the service of economic opportunity for all, regardless of who you are and whom you love. I yield back.
Thank you. The ranking member, Mr. McHenry, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. Republicans and Democrats agree. Data and facts are important. Data and facts are important for diversity and inclusion. Data and facts are important to ensure that we have proper enforcement of law. Data and facts are important for us to take the proper actions to root out discrimination where it exists. Each American company is unique, and a mandatory reporting regime cannot accurately measure progress. However, the bill we have in front of us does not impose a mandatory reporting regime. In this case, the data collection happens on a voluntary basis. That's positive. The bill states specifically that loan applicants have the right to refuse to provide any of the pieces of data included for collection. Given that fact, I have fewer concerns over privacy or a one-size-fits-all data reporting regime. And I'll say the addition of this sense of Congress at the last minute does give me some pause because this is not something we had not previously seen or discussed. But that's something we can discuss as this bill moves forward. I do think that this is a proper move in keeping with what we've learned from the Supreme Court and their recent rulings. I think it's a proper move for us as a society. I think it is a measured approach and a thoughtful approach. I support the measure and would yield back.
Thank you. Is there further discussion of our amendment to the amendment in the nature of a substitute? If not, I recognize myself for 5 minutes. I strongly support the LGBTQ Business Equal Credit Enforcement and Investment Act by Representative Torres of New York. Notably, the ranking member began his remarks that none of the bills in this hearing would support small business. Well, truth be told, that's the main point of this bill. H.R. 1443 would provide the necessary data to better understand and combat discrimination against the LGBTQ community in lending by requiring financial institutions to collect information from LGBTQ business owners, loan applications, and report this data to the Consumer Financial Protection Bureau. It will also define an LGBTQ-owned business in the Equal Credit Opportunity Act, which would allow more businesses to gain access to capital and investment through private and government procurement contracts. Unfortunately, LGBTQ individuals face discrimination in today's lending and credit markets. For example, in 2019, Iowa State University researchers found that same-sex couples were 73% more likely than heterosexual couples to be denied a mortgage. We know less about the barriers faced by LGBTQ borrowers applying for small business loans because this data is not collected in a systemic way. LGBTQ individuals turn to business ownership to help create community wealth through development and job opportunities. As of 2016, there are about 1.4 million LGBTQ-owned businesses in the United States. The CFPB needs to begin collecting this data, which help us as policymakers and the public identify and understand the needs of and barriers faced by LGBTQ business owners. This important legislation is endorsed by a number of organizations, including the Center for American Progress, Center for LGBTQ Economic Advancement and Research, Human Rights Campaign, National Center for Transgender Equality, National Gay and Lesbian Chamber of Commerce, National LGBTQ Task Force Action Fund, and the National Center for Transgender Equality. I would like to thank Representative Torres for leading this bill, which will help lenders better serve all communities. And I urge all members to support the bill, and I yield back the balance of my time. Is there further discussion of our amendments to 1443, H.R. 1443? If not, the question now occurs on approving the amendment in the nature of a substitute. All those in favor say aye. Aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering 1443 as amended to be reported favorably to the House. All those in favor say aye. Aye.
Aye.
Aye.
Aye.
Those opposed, no. In the opinion of the chair, the ayes have it. The ayes have it, and H.R. 1443 is expected to go on, yes, certainly, by voice. We have a voice vote. 1443. 1443 certainly has been agreed to. Thank you. Pursuant to notice, the chair now calls up H.R. 3009, the Improving Language Access and Mortgage Servicing Act. The clerk will report the bill.
H.R. 3009, a bill to amend the Truth in Lending Act and the Real Estate Settlement Procedure Act of 1974 to establish language access requirements for creditors and servicers and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. Section 1, short title.
Without objection, the first reading of H.R. 3009 is dispensed with. The gentleman from Texas, gentlewoman from Texas, Ms. Garcia, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and are also on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 3009, offered by Ms. Garcia of Texas. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the improvement.
Without objection, the amendment in the nature of a substitute will be considered and read and considered base text for purposes of further amendment. I now recognize the gentleman from Texas for 5 minutes to explain the bill and her amendment. The gentlewoman from Texas for 5 minutes to explain her amendment.
Thank you, Madam Chair, and thank you for the opportunity to present this bill before this committee. I'm here to call on my colleagues to support H.R. 3009, the Improving Language Access in Mortgage Servicing Act. This bill will make it easier for people whose primary language is not English to remain homeowners by ensuring that mortgage servicing companies speak to them and provide documents in their own primary language. Speaking another language should not prevent anyone from attaining the American dream of homeownership. Buying a home is the ultimate investment in one's own community. It is how we put down roots, it is how we become a part of this great country, and it's how we pay taxes to help fund our community and our country. As leaders, it is our duty to facilitate access to homeownership for everyone. No matter which language you grew up speaking, you should be able to purchase a home. You should be able to work with your lenders to pay it down and achieve full ownership of that home. Under this bill, homeowners will be able to better communicate with their loan servicing companies on issues like taxes, loan status, payoff amount, and escrow. Better communication leads to better understanding of one's responsibilities, which will in turn increase compliance and prevent foreclosures. Admittedly, this documents and terms can be complex and hard to understand, even in English. I know that even myself as a lawyer, I have a hard time sometimes going through what my mortgage company sends me, so I can only imagine if there is a language barrier involved. We should do our part to make sure that folks whose primary language is not English fully understand such complex documents. Everyone should know what they're getting into when they sign a legal document. This bill is designed to improve language access in lending and servicing in residential mortgage loans. It does not mean interpreters on demand in any language. It provides documents to be translated in the 8 most common use languages as determined by the Consumer Financial Protection Bureau based on census data. As a Latina and as someone who represents a district that's 77% Latino, I can tell you firsthand that I have seen a lot of folks that have problems not only with their mortgage documents, but their loan documents, their servicing documents, because it is in English and not in their own language. So I urge my colleagues to support this bill, support the home buyer, so that we can be inclusive of all people who work hard to become a fabric of this society and want to own a home. Diversity is what makes us great. This bill will support our homeowners so that they can continue investing in their communities and building our society. Madam Chair, I also would like to enter for the record a support letter from the Americans for Financial Reform who support this bill, together, of course, with support from the National Consumer Law Center, Unidos USA, National Fair Housing Alliance, National Housing Resource Center, National Housing Law Project, Asian Real Estate Association of America, National Association of Hispanic Real Estate Professionals, Inclusive Communities Project, Avenue Community Development, and California Reinvestment Coalition.
Without
among others.
objection, such is the order.
And with that, Madam Chair, I yield back.
Thank you. Is there further discussion of or amendments to the amendment in the nature of a substitute?
Madam Chair, I have an amendment at the desk.
The gentleman from Georgia, Mr. Scott, is recognized for 5 minutes to strike the last word.
Yes, to strike the last word, I just want to say a very strong word of support for what Ms. Garcia is doing and why this is so important. Ladies and gentlemen, you see, oftentimes there can occur gaps in information that's caused by language barriers that still can cause borrowers to fall victim to discrimination, to scams, to traps. The evidence is clearly there. So what Ms. Garcia is doing is this. She is simply ensuring that servicers and creditors provide borrowers with translated documents and interpretation services so that we can build a higher standard of accountability, of safety, and trust to ensure that no borrower is treated unfairly simply because of the language that they speak. That's it simply, and I'm proud to support this bill, and I urge my colleagues to vote yes. Thank you, and I yield back, Madam Chair.
Thank you. For what purpose does the gentleman from Georgia seek recognition?
Madam Chair, I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed electronically. Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3009, offered by Mr. Loudermilk of Georgia. On page 4, line 23 through 24.
Objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment. Mr. Loudermilk?
Well, thank you, Madam Chair. This bill would require mortgage lenders and servicers to provide oral interpretation services for any consumer with limited English proficiency who has informed the lender of a preferred language in one of the 12 most commonly spoken languages. However, the bill is unclear as to, 1, what is or is not required to be orally interpreted, 2, who is to provide the interpretation services, and if or how the interpreter will be accredited or selected, 3, who is to pay for the services, and 4, what liability might arise from information that may be miscommunicated through these services. My amendment would direct the CFPB to select interpreters to be used by the lenders and servicers and ensure that the lenders and servicers are not held liable for denials, misinterpretation, or misunderstanding of documents. Lenders understand the need to serve customers in their communities. Many lenders already provide interpretation services based on commonly spoken languages in the branch locations and offices. Increasing requirements and costs based on an arbitrary list of languages spoken nationwide does not address the needs of local communities that could actually benefit from translation services. Simplified loan documents and targeted language resources would more effectively assist lenders with serving their customers. This will ensure borrowers not only impacted by additional costs when going through the mortgage process, that they are not impacted by additional costs when going through the mortgage process, but in the meantime, we should not hold lenders or service providers liable for mistakes. I urge my colleagues to support this amendment, and I yield back.
Further debate on the amendment?
Madam Chair, I move to strike the last word.
The gentlelady from Texas is recognized for 5 minutes.
Madam Chair, I urge my colleagues to oppose this amendment. I think the amendment is unnecessary. I don't think that there is anything in this bill that would expose any liability. In fact, if the gentleman would look at page 3, line 20, beginning at line 20 and into the next page, the bill specifically provides that the translated documents are for informational purposes only, and that the English version is the official and operative document, and the translated version is for informational purposes only. So it is telling everyone that the English version is the one that is the sole trigger for anything that might happen. And, you know, I beg to differ. This is not going to be something that's for any arbitrary language. Again, it would be the 8 most commonly used languages as determined by the Bureau based on census data. And I don't see why this bill would need any amendment like this, so I oppose the amendment. May I yield back?
The gentleman from Missouri, Mr. Lukemeyer, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I do move to strike the last word. I appreciate my colleague from Texas is trying to accomplish with this bill. Ensuring consumers are fully aware of the requirements placed on them is a key component to ensuring the success of both borrowers and lenders in any loan agreement. However, this legislation raises more questions than it answers. The underlying bill will require the CFPB to establish a standard language preference form, which includes a standard language preference question asked in each of the 8 languages most commonly spoken by individuals with limited English proficiency. It would then place onerous burdens on creditors and servicers to include the standard language preference form in any residential mortgage loan application and multiple required notices. Then creditors or servicers are required to provide a translated document to a borrower if one is available by the federal, state, or local government. The creditor or servicer must also provide a notice that the translated documents are simply for informational purposes, and the English language version is the official version. As if this additional documentation was enough, creditors or servicers must then provide oral interpretation services for any consumer who selects one of the 8 preferred languages. This regulatory hopscotch with loan documents, notices, and interpretations will only increase costs for servicers and creditors and prices for consumers. Moreover, the bill leaves too many questions unanswered to understand how all of these regulatory hoops will play out practically in the mortgage servicing process. Sounds like another government overplay to me. For example, the bill does not outline what is or is not to be orally interpreted. It does not outline who is to provide oral interpretation services or how they will be selected or if they need to be accredited in some manner. This legislation also fails to mention who will pay for these services and perhaps most importantly, does not assign any liability that might come from miscommunications of translations. My colleague, Mr. Loudermilk, has introduced an amendment that brings some clarity to this muddled legislation. The amendment requires the CFPB to provide the translators necessary to carry out the numerous actions of this legislation. Not only would this provision notify creditors of where to go to acquire a translator, it would ensure the translators being used would be approved by the CFPB and therefore have received some vetting. This amendment also clarifies that creditors and servicers are not liable for any credit denials, misinterpretations, or misunderstandings that may arise from inaccurate interpretations. This is the critical provision that will allow the gentlelady's legislation to operate without fear of prosecution and the immense litigation that could come from translated mortgage documents that are only used for informational purposes. I applaud my colleague from Georgia for trying to improve this legislation so it can be a bipartisan effort. I still have many concerns regarding this bill, but do believe this amendment is a significant step in the right direction. And with that, I urge my colleagues to support the amendment. And Madam Chair, I yield back. Thank you.
Is there further debate on the amendment?
Madam Chair.
The
Madam Chair.
gentlewoman from Pennsylvania, Ms. Dean, is recognized for 5 minutes to strike the last word.
I thank you. I move to strike the last word. Thank you, Madam Chair, for recognizing me. I rise in opposition to this amendment and in strong support for Representative Garcia's legislation. It is smart legislation. Like Ms. Garcia, I am an attorney and have long fought for plain English documents for language for consumers. This is a smart and important extension of that. I think back on the founding of our country, and property rights were central among our founders' inclusion of rights. They wanted to have folks establish their homes, own property, and language should never be a barrier. So this is a smart piece of legislation. I can't imagine why anybody would want to oppose it. What it would do is have the Consumer Financial Protection Bureau create standard language preference forms for use by creditors and servicers to track language preferences and to translate such information on the loan, protecting the original document in English as the legal document. The bill would require relevant federal agencies to establish and maintain language resource websites for mortgage originators and servicers. And so with that, I just thank Representative Garcia for what she's trying to do to make sure we remove any barriers to home ownership and investment here in our communities. And with that, I yield back.
Thank you. Is there further debate?
Green from Texas, Madam Chair, I'd like to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Madam Chair.
Mr. Green, gentleman from
Yes.
Texas, thank you.
I too support Ms. Garcia's legislation. One of the things that can happen and has happened is for lenders to attract persons in their native language. But once you're there and you're about to negotiate and actually have the documents presented to you, they're not in your native language. This is a polyglot society. And I think that it's time for us to acknowledge that some languages are so predominant that they ought to be translated for persons who speak these languages. It really has come now to a point where we either have to accept the society as it is, or we're going to have persons to be harmed by virtue of not being able to communicate in a language of their choice. I support what Ms. Garcia is doing, and I commend her for bringing this to our attention. I yield back.
Is there further debate on the amendment? If not, I withdraw my point of order. We have a slight delay. Thank you very much. I now recognize myself for 5 minutes. I am extremely supportive of Ms. Garcia's legislation. Of course, as it has been said, this bill would certainly make it easier for people whose primary language is not English to remain homeowners by ensuring that mortgage servicing companies speak to them in their primary language. Ladies and gentlemen, at this point in time in the history of this country, where we are blessed with the kind of diversity that we all claim to support, it is very important that speaking another language cannot, should not prevent anyone from attaining the American dream of home ownership. The American dream of home ownership is something that is absolutely needed, wanted, and pursued by all those who value this democracy and living in this country. And so, not only do I support Ms. Garcia's resolution, her bill, H.R. 3009, the Improving Language Access in Mortgage Servicing Act, I would ask all of my colleagues to please vote aye on this legislation. I yield back. Is there further discussion or amendment to the amendment in the nature of a substitute? Excuse me. Is there further debate on the amendment? If not, I will withdraw my point of order, and the question now occurs on the amendment. All those in favor of the amendment say aye. Those opposed, no.
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 Aye.
No.
Aye.
In the opinion of the chair, the noes have it.
Aye.
The noes have it, and the amendment is not agreed to.
Roll call vote, please.
A recorded vote has been requested. All in favor of a recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion of or amendment to the resolution? If there are no further amendments, without objection, the previous question is ordered on H.R. 3009, and pursuant to Section C5 of Committee Rule 3, further proceedings on the pending amendments are postponed. Pursuant to notice, the chair now calls up H.R. 2570, the Climate Risk Disclosure Act. The clerk will report the bill.
H.R. 2570, a bill to amend the Securities Exchange Act of 1934 to require certain disclosures relating to climate change and for other purposes. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. Section 1, short title. This act may be cited as the Climate Risk Disclosure Act of 2021. Section 2, sense of Congress. It is the sense of Congress that climate change poses a significant and
Without objection, the first reading of H.R. 2570 is dispensed with. The gentleman from Illinois, Mr. Casten, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and also on the dais. The clerk will read the amendment.
amendment in the nature of a substitute to H.R. 2570, offered by Mr. Casten of Illinois. Strike all after the enacting clause and insert the following. Section 1, short title.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentleman from Illinois for 5 minutes to explain his bill and the amendment.
Thank you, Chair Waters. As this committee knows, I have dedicated my life to fighting climate change, first as a scientist, then as an engineer, an entrepreneur, and of course now as a member of Congress. As this committee may not know, early in my career, that made me a straight ticket Republican voter. That was primarily because the Republican Party of the 1980s and 1990s understood that while the laws of physics were non-negotiable, markets, properly harnessed, are powerful solutions to environmental problems and are preferable to command and control alternatives. The Montreal Protocol and the 1990 Clean Air Act amendments passed by the Reagan and first Bush White Houses are examples of that philosophy in action. And this bill is crafted in that spirit. We all know that climate change is a risk to the stability of the global financial system. My bill represents a market-based solution to understand the impact of a changing climate on companies and provide investors, lenders, and insurers with better information. The Climate Risk Disclosure Act of 2021 would require public companies to disclose more information about their exposure to climate-related risks, which will help investors appropriately assess those risks, ease the transition from fossil fuels to cleaner and more sustainable energy sources, and cheaper, I would add, and reduce the chances of both environmental and financial catastrophe. We must act now to address climate change. Based on a report issued by the Intergovernmental Panel on Climate Change, urgent and unprecedented changes are needed to limit the global average temperature to a maximum of 1.5 degrees Celsius. To even get to this goal would require, quote, rapid and far-reaching transitions in energy, land, urban, and infrastructure systems, including transport and buildings and industrial systems. The Earth has already warmed by about 1 degree Celsius or 1.8 degrees Fahrenheit since the 19th century, and the rate of warming is increasing. In point of fact, over half of all of the carbon dioxide we have ever emitted as a species throughout our entire history on this planet has come since 1991, after the Clean Air Act amendments of 1990. This is not just the planet getting warmer in some abstract sense. If we do not curtail our emissions, it will have disastrous impacts on normal people's lives. In just the past few decades, rising temperatures have caused more extreme weather events, longer and more destructive wildfire seasons, and expanded territories for mosquitoes that spread disease. Setting aside the human impact, the monetary damages are already in the hundreds of billions of dollars. Additionally, a study by Swiss Re recently found that global GDP will decrease by 4% if we meet the Paris goals of 1.5 degrees of warming. If we stay on the business as usual trajectory we're on, the global GDP loss will be 18%. And investors get this. ESG funds already comprise $37 trillion. Bloomberg article released in February 2021 says that we are on track to hit $53 trillion in ESG funds by 2025, representing more than 1/3 of total assets under management. Now more than ever, it is critical for companies to consider the impact of climate change and associated mitigation and adaptation efforts on their strategies and operations and disclose related material information. Thinking through this type of risk better equips companies so that they can start building sophisticated models that properly project the full gamut of financial risks and opportunities associated with climate change, eventually integrating those models into their decision-making and adapting their business models accordingly. Alternatively, companies that invest in activities that may not be viable in the longer term may be less resilient to risks related to climate change, and their investors may experience lower financial returns. That is the market functioning correctly, and that is only possible with clear disclosures. Investors and insurers are pushing for greater disclosure. Climate change is introducing greater physical risk and uncertainty into the financial system, both by causing physical damage to companies' assets, infrastructure, and supply chains, and by catalyzing market transformations that threaten to make some traditional business models obsolete and create opportunities for others. That's why investors care, not out of some financially naive moral judgment. They care because it is in their self-interest to protect their financial well-being from those risks. But our current lack of consistent and mandatory reporting makes it impossible for investors to secure that edge. Recent MIT research has found that, quote, ESG scores from the 5 main ESG data providers are uncorrelated for any given company. That is not a criticism of ESG reporting, but it is a damning indictment of voluntary and inconsistent reporting. This year, the SEC has acknowledged that truth. On March 15th, the SEC requested public input on their disclosure rules and guidance as they apply to climate change disclosures and whether and how they should be modified. While I believe the SEC doesn't need any additional authority to act, my bill codifies that public companies must disclose more information about their exposure to climate-related risks. Many companies already make these disclosures, but more needs to be done. According to a 2017 KPMG study, half the world's largest companies are acknowledging climate change as a risk.
The gentleman's time has expired. The gentleman from Michigan, Mr. Huizing, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. And as I move to strike the last word, I am wondering if Mr. Casten would entertain a few questions about the bill. And I know he's put in a lot of hard work. It's a very extensive bill. And I think there's a couple of things I'd like to clear up. So with the gentleman's permission, I'd like to ask a few questions.
Of course.
When discussing these SEC disclosure bills, you and your colleagues, Democrat colleagues, have frequently described how shareholders want this information from companies and are increasingly trying to get it. In fact, you mentioned that in the text of the bill, I think on page 3. Can you tell me how many shareholder resolutions requiring information mandated by your bill have won a shareholder vote?
I have no idea what the answer is to that question, and I'm not sure it's material. I think the meaningful point is that 1/3 of assets under management are ESG funds right now, so shareholders clearly care.
I would think it is actually material. It's interesting that you say that, ask whether it's relevant or not, because I mean you are saying that this is of importance to people and information is of importance. And so I'm wanting to know if any shareholder resolutions requiring the company's quote, and I believe these are your term, social cost of carbon, has actually won a shareholder vote.
Again, I question the significance of the question. We have on this slide.
Well, we'll move on from that then. In Senator Warren's press release announcing the introduction of her Senate companion to your bill last month, it states this bill will, quote, accelerate the market transition from fossil fuels to cleaner and more sustainable energy sources that mitigate climate change, close quote. So is the purpose of this bill to enhance shareholder value or to reduce greenhouse gas emissions?
Those terms are synonymous. Anything we do to accelerate the transition to a cleaner economy is also something we do to transition to a cheaper economy. It's a massive wealth transfer from energy producers to energy consumers because clean energy is cheaper. That will be dislocating in our financial system, and people have an expectation to understand where that wealth transfer is going to occur.
So you have drafted this with the very distinct purpose of using securities laws and disclosures to address climate change, and with the predetermined conclusion that investment in companies that are not green are bad. I mean, is that your intent?
That is not at all my intent. This is an investor protection bill. If you are invested in a company,
therefore, companies that are not, quote, green by your standards or this language standards, then they are bad investments.
No, I'd like to clarify the term. If I am an investor and I want to make sure that my portfolio is not at risk of loss from a warming climate or contributing to something that will offset another investment I may hold, I would like to know that. I would like to know that in a consistent fashion, not because I'm making a moral judgment, but because I'm making an economic judgment.
So here's the interesting thing, though. The SEC is not a merit-based regulator. That is not what they are, meaning it generally does not. It's not in the business of picking what are good businesses and favored companies versus others. So it is appropriate to use the SEC's disclosure regime in an attempt to achieve a predetermined, congressionally directed social goal, is how I see it from what you've put down on paper here.
I think
again, is that your intent?
I would reiterate what I just said. I didn't say that this was a morally determined social goal. What I said is that there are investors who want to know what the risk is they're exposed to and how to hedge against it. You don't have.
So I go back to my first question, which is, have any of these shareholder proposals actually been passed and adopted? I mean, if there's so much clamoring for this, it seems to me you're wanting to use the blunt edge of the SEC to do this. And frankly, I'm not sure that the SEC is prepared, equipped, or able to do a good job on this. You look at conflict minerals, you look at a number of the other things. Mary Jo White herself had said when it came to conflict minerals as part of Dodd-Frank, that this was not the role of the SEC. And I guess a rhetorical question in a way is, how in the world are we going to know the goal is accomplished? And when it does the SEC have to continue regulating in the way that it currently would be mandated to do? So my time is up. The main element of this is materiality, how these definitions are going to be defined. And I think that this attempt misses that mark, and we really do need the market to demand that, not have the SEC come in and demand that. My time has expired. I yield back.
The gentleman from Georgia, Mr. Scott, is recognized for 5 minutes.
Thank you, Madam Chair Lady. First of all, I want to commend Congressman Casten for this excellent and timely and much needed piece of legislation. And I want to kind of respond to my good friend, Mr. Hussinger there. This impacts our investors. We owe it to them to protect the investment. It is the cornerstone of our economy. And so, and I'm deeply concerned about the risk that climate change poses to all of our businesses, our markets, and our livelihood. And let me just explain why for a moment. I've gotten really involved in this issue as chairman of our Agriculture Committee. And I know all too well how our farmers, our ranchers, they had to prepare every single day for the potential devastating climate-related disaster, floods, hurricanes, fires, tornadoes, every single day. And similarly, it is essential that our public companies are also prepared every day for our investors to take on this risk. This Climate Risk Disclosure Act that Mr. Casten is putting forward is long overdue. And what he is doing here is simply ensuring that public companies simply disclose their climate-related risk, providing investors with a clear view of what that climate exposure is.
Well, my
It's
gentleman,
very helpful.
will my friend from Georgia just recognize me for just a moment to make
Yes,
an observation?
go ahead,
I appreciate that. You're talking about the SEC protecting those investors, and that is one of the requirements of the SEC. But in no other area does the SEC determine whether an investment is worthy or good. It simply keeps investors safe by requiring that material information is not hidden from them. That's why the books have to be open. That's why all those things. This is a very different issue, in my opinion. I yield back.
Sure. And I could agree with you if we were not living in a time where climate change is now this nation's #1 issue. And all I'm saying to you is that as I realize, for example, as chairman of agriculture, it is our single most important industry. And that's why I am so concerned about this. Nobody is impacted by the weather as our farmers in agriculture, our food security, our clothing, the water we drink, the clothes we wear, our shelter, all the basic elements in agriculture. So I'm speaking to this to let you know how important that these common sense disclosures that Mr. Casten has in his bill is taking a necessary step towards protecting investors and strengthening our markets. Let me tell you, and you could have a point sometime back, but the climate is changing, and we must change to protect our full aspect of our economy. And I'm speaking to you from just having an historic hearing on climate change in our Agriculture Committee. Yes, go ahead.
Thank you. And I agree that we need to address this. However, we cannot have common definitions that are being sought. We have no common definitions. We have common definitions of what GAAP standards are for accounting and so many other things. That isn't applicable at this point, and unfortunately, this doesn't hit that mark. I yield back.
The gentleman from Arkansas, Mr. Hill, is recognized for 5 minutes to strike the last word.
Well, thank you, Madam Chair, and I thank my colleagues for this constructive debate. And this is a topic that we've talked about in the last Congress and in this Congress on a number of points. And I appreciate Mr. Casten bringing back his views in the form of his bill and his amendment in the nature of a substitute. So mandated environmental disclosures, despite not having fully agreed upon financial definitions and even the science aspect of those financial definitions to back them up, are once again, at the forefront of this legislation that we're considering. Now, a few weeks ago, my friend Mr. Vargas' legislation, the ESG Disclosure Simplification Act of 2021, was marked up, and we are now marking up Mr. Casten's climate-related disclosure bill. Both bills address the need for climate-related disclosure, but in completely opposite ways. For a process that's supposedly based on financial facts, even the members on the other side of the aisle can't agree on what those facts should be. These bills exemplify the exact warnings that I've outlined in the last Congress and I've mentioned over the past few weeks. Let me explain. Congressman Vargas suggests that a disclosure system is sufficient by providing an annual report describing the long-term climate strategy and climate-related metrics for that business. Congressman Casten, however, says that a disclosure should report those same metrics, but needs to also disclose the social and human impact of a company's actions, costs related to international treaties, analysis of how the company's reputation may affect cost, and detail the board's oversight, and the list kind of goes on and on. These two pieces seem to differ on what those metrics are needed. Congressman Vargas requires a company's current metrics. Congressman Casten's proposal, companies must disclose current metrics, any risks posted, potential risks, and implications of these risks, and the effect on company strategy. So what I'm trying to figure out is that if the committee majority is so set on reporting these climate metrics, and it's such a straightforward objective of the majority, why do these bills differ so significantly? So I too have a couple of questions in looking at Mr. Casten's proposal. He has a long list of very technical climate-related data points to be included in subsequent SEC rulemaking for his bill's proposed disclosures. And with any disclosure, the SEC's work doesn't end at the rulemaking. Once it's adopted, the SEC work continues from there to review and enforce company disclosures under the rules he suggests. To properly do that, the SEC is going to have a high fluency in climate and environmental science. So I asked my friend from Illinois, Mr. Casten, do you think the SEC has sufficient climate and environmental scientists currently employed there to try to provide that guidance and interpretation, enforcement, writing, drafting, reviewing in that regulatory process? And if not, would they divert funding from enforcement or some other major goal? Mr. Casten, I yield to you.
Yeah, so thank you for, thank my friend from Arkansas for the questions. And, you know, I think you are exactly right with the need. And I would point out that the fact that we're having this conversation here is more reflective of the fact that the United States has ceded of leadership on the global stage. In the Glasgow climate COP26 that's coming up, one of the tracks is carbon accounting for businesses to make sure that we don't double count. There's a rich conversation about scope 1, scope 2, scope 3 emissions. The rest of the world, Mark Carney is leading, is on this train. And there's a recognition that our financial regulators need to come up with consistent standards. Consistent with what Mr. Huizenga was right. We have common definitions of CAP standards, but we don't have that for this, I think was what you said, Mr. Huizenga. That's true. And that's why we need to develop those standards. And if that means that we need to beef up our financial regulators to have the ability to do that, that's fine. We would be far from the only country that's doing that.
Thank you. Let me have a quick follow-up in the few seconds that remain. So Mr. Vargas also exempts small businesses from his proposal. You don't exempt any businesses from your proposal. Do you think that small cap stock should be exempt from this kind of work?
I think it's appropriate for SEC rules to apply to all public companies. Frankly, as someone who used to run a private company, my own private equity investors insisted on much more stringent guidance than this, but it's appropriate for public companies.
And if rules are not clear and there isn't really agreed upon metrics, do you think that increases litigation risk for a proposal like yours for reporting companies?
I think, frankly, it's good for companies to report on a consistent framework. The companies that I've spoken to don't like the idea that right now their competitors have different reporting rules than they do because they're all voluntary.
Yield back, Madam Chair.
Thank you. The gentlewoman from Texas, Ms. Garcia, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I move to strike the last word and to rise in support of this bill. I think it just makes sense in today's world that we do provide investors with the climate risk exposure that their companies might have. I know Mr. Casten has been working on this for some time. I supported this bill last session. I intend to vote for it again. And with that, I yield to the sponsor of this bill, Mr. Casten, if he'd like to finish up the remarks that he was making at the opening. And I know he felt the gavel go hard, or if he wants to respond to any of the comments that have been made from some of our friends across the aisle. With that, I yield to Mr. Casten.
Well, I thank my friend from Texas for offering me the time. I'll try to be brief and not use up all of it. I do want to just respond to the comment that Mr. Hill made about small cap versus large cap companies. The SEC's job is to protect investors, and investors don't distinguish between small and large cap companies. And so it's important for us to protect them all as well. The only comment I'd make that I didn't get to at the start was just to offer some wisdom that, you know, as you know, I spent 16 years building and running clean energy companies. We held ourselves to standards that our competitors didn't. And one of my board members was fond of saying that the only thing that matters in this life is whether our children look back and say that they were proud of us. And I hope that today we will all comport ourselves in a way to make our grandchildren proud of us. Thank you, Ms. Garcia.
Thank you. With that, Madam Chair, yield back.
The gentleman from California, Mr. Vargas, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I move to strike the last word. First of all, I want to thank my good friend from Illinois for his dogged pursuit of climate change, adaptability, and sustainability. The changes that we need are significant. And the reality is that many of the problems that we are facing today deal with climate change. Immigration, for example. You have a disaster that happened in Central America. It was hit very, very hard with 2 hurricanes, Category 5s, then became Category 4s as they came on shore and dumped an enormous amount of water on Honduras in particular, wiped out many of the crops. People who were subsistence farmers just simply couldn't make it, and now they're migrating. So I want to thank him again for his dogged pursuit of the issue of climate change. I'd like to say also to my good friend from Arkansas that there is no contradiction in Mr. Casten's bill and my bill. In fact, I think they're very complementary. It's the opposite. They're very complementary. And I appreciate his approach very much, and I appreciate his market-based solutions that he provides in this bill. One of the things also that I'm thankful for is I think that most of us now do believe that climate change is real. That took a long time just for my friends on the opposite side of the aisle to accept. I think they've accepted it now. And what do we do about it? Although I don't think they've accepted yet that it's also based on some human causes. It's just simply, I don't know what they think, but they say that it's cows farting and hurricanes and all these other things. But the reality is it's human beings, it's carbon in the atmosphere too. But there's other things that they can argue about, but it's also human cause. And we have to do something about it. And I think that this bill does quite a lot. I'm very much in favor of it. I would also say, though, when companies take a look at, there's opportunities also in my district in Imperial County. We have geothermal energy and finds that geothermal energy is great. And interestingly, too, one of the things that happens when you put a pipe deep into the earth and bring out some of the heat to spin what you need to make electricity, you also bring out other things, including lithium that can be used for batteries. Now they're trying to figure out, the smart companies, how do we use that lithium instead of sticking it back down into the ground, which we're doing right now. And again, I think it's very important that we take a look at these opportunities. These are opportunities. And again, I want to thank my good friend for this bill. I would say that today is a momentous day. I'm glad that you mentioned the whole notion of, you know, are your kids proud of you? You look back. I do think it's a banner day today. Not so much even for this bill. I think this bill is important, but what happened today, I think, in the Republican caucus, sadly, we had a person today, I think, and I think history will mark this day. I think it will be marked in stone. We had a situation where a person in leadership stood up and told the truth that I think most Americans understand. And because of that, she was severely punished by her own group. Let's not stick our heads in the sand here and deny climate change and the opportunities and also the problems that it brings. And I think that this bill approaches it in a very market-based way that makes sense. And by the way, most of us, including myself, an investor, I want this information. It's material to me. And a lot of the large companies understand that, and they're providing it, but there is no standard. We have to create those. So again, I want to thank Mr. Casten. I do think it's you know, if we're going to be good stewards, in Catholicism, we call it stewardship. If we're going to be good stewards of the world, I think that we need to make sure that our companies are good stewards too. Not in the issue whether it's a good company or bad company, whether they're doing the right thing that's sustainable, whether they're doing the right thing for their own company, to make sure that they're profitable, and for our environment and for our society. So again, I don't know if Mr. Casten needs any more time, but if he does, I'd be happy to yield to him. Again, I thank him for this bill.
Thank you for the 30 seconds, but I will yield back to the chair.
I yield to. Thank you.
The gentleman from Kentucky, Mr. Barr, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I do strike the last word. And I do appreciate Mr. Casten's indulging my colleagues' questions. I have a few questions as well, if Mr. Casten would be kind enough to share his insight. We've had informal conversations about his legislation on the House floor, and I want to ask a few additional questions if he would indulge me. Let me start, Mr. Casten, with this conversation about disclosure rules and not differentiating between small cap, medium cap, and large cap companies. That's precisely what the Jobs Act did. It didn't exempt small cap companies from every disclosure, but it did provide graduated or differentiated disclosure requirements based on the size of the company and tailored those requirements based on size. That's part of the ecosystem of existing securities law and was in fact enacted as part of the Jobs Act, which was a capital formation bill, bipartisan, that many on your side of the aisle, Mr. Casten, applauded. My question to you is, do you regret enactment of the Jobs Act given the lack of uniformity that you seek in this disclosure bill?
Well, to your first question, it is always a pleasure to indulge you, Mr. Barr. I think these are separate issues, and no, I don't regret. I mean, one of the things that I think folks don't appreciate enough with climate is that if I If I, as a CEO, say I'm going to divest my operations in a country that doesn't enforce our child labor laws, your auditor then goes in and says, okay, show me where you are accelerating the depreciation of assets, showing where you're moving capital. If, on the other hand, I, as a CEO, say I'm going to be net zero in 10 years, your auditor doesn't have any guidance. And that doesn't matter if you're a small company or a big company. It means that investors, who may be big investors or small investors, want to know that you are doing what you say they're going to do. And I think it's appropriate.
If I could reclaim my time, I think you've made your position known that you want small companies to be burdened with these disclosures. But let me ask you about direct and indirect greenhouse gas emissions.
Public companies, to be clear.
Yeah, I understand, but there are smaller public companies too. I'd like for you to help me understand what counts as a direct greenhouse gas emission and what counts as an indirect greenhouse gas emission. In your bill's definition section for direct and indirect, it lists all indirect greenhouse gas emissions that are attributable to assets owned or managed, including assets that are partially owned or managed by the covered issuer. My question is that under this definition, would company-owned computers and printers that are not solar powered be included in this category? And would company-owned cars be included even if it's a Tesla or a Prius?
There's a rich discussion that's probably more than we have time for here between scope 1, scope 2, and scope 3 emissions. But the basic idea is that direct emissions, scope 1, you burn fossil fuel on your premises, you're responsible for that. Scope 2, you buy something that required fossil fuel to produce it. So maybe you buy nuclear power to fuel your Teslas, you buy coal to fuel your Teslas, you have a different impact there. Scope 3 emissions within what you purchase, and frankly, the international accounting rules are still struggling to come up with that. But the idea that our international partners are trying to come up with is that in the same way that companies' liabilities add up and the great balance sheet in the sky still balances, we need to have.
Well, I think we're getting to the workability. I think we're getting to the workability and the practicality of the legislation. And the question would be, would companies that rely on solar power or use electric vehicles be required to trace the climate change impact of battery cells in the solar panels or the source of energy that feeds into the electric grid? Isn't that an indirect potential emission?
So I think the question of exactly how to implement and how to do the carbon accounting is a job that's best left to the regulators, not us legislators. But you're quite right. You're quite right.
Delegate that to unaccountable, unelected bureaucrats at the SEC, and that would result in climate disclosures for solar panels or battery cells. That I think that does illustrate the admission of how broad-ranging the bill is. Finally, let me ask you one final question. With such an expansive definition of indirect greenhouse gas emissions, are you worried that companies will be more hesitant to pursue expanding or acquiring other companies? I mean, absent your bill's disclosures, expanding or acquiring another company might be a really strong financial move for the company, but they may choose not to pursue such an economically productive opportunity or go public just to avoid having to report these seemingly undesirable information in these disclosures.
Again, I don't see the tension. The rest of the international world is already going down this track.
Well, I see the tension. I see the tension. I think these owners' disclosures are going to be a huge disincentive for acquisitions. But I yield back.
Madam Chair.
The gentleman from California, Mr. Sherman, is recognized for 5 minutes.
Thank you, Madam Chair. In February of this year, we in the Investor Protection Subcommittee had a hearing on climate change and social responsibility. And I think that hearing showed the importance of passing this important legislation. I've had those on the other side of the aisle talk about how we need to let people do what they want to do. If they want to invest without investor protection, if they want to invest in unregulated securities, et cetera. Maybe that's the case, maybe it's not. But certainly, if people want to invest in a socially responsible way, if they want to invest in companies that are mindful of the effect they're having on the planet, they ought to have the tools they need to make those decisions. And for us as a government to say, you can only invest for earnings per share. You're not allowed to care about anything else. We're going to deprive you of information about how the companies you invest in are affecting your planet and your children. Strikes me as dictatorial and patronizing. If investors don't want this information, they don't have to use it. But I think an increasing number of investors, including CalPERS, the largest investor in our system, as they testified at our hearings in February, do want information as to how these companies are affecting the environment. But a second part of these disclosures is how the environment is going to affect the companies. Even those investors that are concerned only with earnings per share. What information do they get? They get financial statements about the past. The past is interesting, but what they really care about is the future. Well, the future is that this planet is warming, and that's going to affect future performance. And those investors that care about future earnings per share, which is to say virtually all investors, ought to be told by management how climate change is going to affect the assets and performance of the company. And this bill will give them that important information. I hear from, I do think that as this goes through the legislative process, we ought to be getting disclosures not only from publicly traded companies, but from those companies that have over $1 billion in US revenues, not because you can invest in those companies, but because we ought to know what their social impact is. And we shouldn't discourage companies from being public and say, oh, you can conceal from the public your effect on the environment, but just go private or avoid going public. And I know that people are arguing on the practicality of this. I want to highlight the Sustainability Accounting Standards Board, which has already established a detailed framework for climate risk and carbon emissions metrics. According to that board, there are already 13 US public companies using its framework in regulatory filings with the SEC. So we already have a practical framework for reporting to investors and prospective investors information that those investors want, whether they're concerned with earnings per share or whether they're concerned with the effect that the companies they invest in are having on our globe. So it's time to give investors the information they need and that they want. And I believe that as this bill goes through the legislative process, we will give the SEC the flexibility to make sure that the process of disclosure is very practical. And if the rules have to be modified so that smaller companies have less burdens than big companies, I'm sure that will happen as we go forward. So I'm pleased to co-sponsor this legislation. I believe my time has expired. I yield back.
The gentleman from Ohio, Mr. Gonzalez, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair, and I will yield to my friend, Mr. Huizenga.
Thank you, Mr. Gonzalez. And Mr. Chairman, you know full well that I and my colleagues do believe in investor protection. The question is materiality. That's what we're talking about here. And you threw out the word paternalistic. I can't think of anything more paternalistic than this legislation when the question that I asked Mr. Casten to start with, which is how many of these desperately sought after disclosures have actually won a shareholder vote? And the answer that we've come up with is 0. So I'm looking for information as to whether there has been any of these
shareholder resolutions requiring disclosure of a company's, quote, social cost of carbon,
Well,
whether they've actually
Gentlemen,
won a vote. Our research, just a moment, our research shows that it isn't. Now, I might find it very interesting to find out what types of cars the entire C-suite uses and drives, or whether they have a vacation home that they fly to, but it's not material. It doesn't matter. And when the chair of the committee that is looking at oversight of the Securities and Exchange Commission is putting forward some of these things, it's a little dumbfounding to me. And I do have a question for the chairman, which is, will you join me in asking for, as I ask you, for a hearing on false advertising by these ESG funds? There was a May 7 Wall Street Journal article looking at the S&P 500 and comparing the costs that it is to manage those index funds versus these ESG funds. And it's a massive disparity. Talk about protecting the investor. And there are ESG funds that have an infinitesimal difference between the S&P 500 index funds. What value are they bringing? Zero to the consumer. It's padding their pockets nicely. And that's what we've seen time and time and time again when we use the Securities and Exchange Commission to do things it is not set up to do. We get to hire more consultants, we get to hire more experts, quote unquote, and that really is not what the Securities and Exchange Commission is about. It is, and as you well know, it is not a merit-based regulator. It is not in the job of determining what's a good company and what's a bad company, or an industry that's a bad industry. It's determining whether it adheres to transparency and gives material information. And my friend Mr. Casten, it's section 2, part D, number 5, on page 3 of his adopted amendment, nature of a substitute. Number 5 says the Securities and Exchange Commission has a duty to promote a risk-informed securities market that is worthy of the trust of the public as families invest for their futures. My friends, you are proposing a radical departure from what the 1933 and 34 Securities Act was set up to do. And we have not had a full exploration of what this all means. And I think, as my friend from Kentucky was talking about, turning this over to unelected bureaucrats because we have decided to abdicate our constitutional responsibility, because it's tough and we might actually have to answer to voters, and just turn this over to the rule makers at the SEC, that's shameful in my mind. Let's at least have the courage to try to develop the details necessary so that these small cap companies who may have a legal department of, nobody on staff, to a massive Fortune 50 company that will have thousands of lawyers on staff, that they're able to deal with it in an equitable way. So I hope, and again, I guess I'll go back in this remaining time. I call on the chair, Mr. Sherman, to hold a hearing on false advertising, or at least let's explore it. You can title it whatever you want, but we need to look at why these ESG funds, which are supposed to be good for the investor, are actually charging a far higher rate than other index funds. That should be a question that we are asking all along with that. And I know my time, Mr. Gonzalez's time has expired.
I yield back to the chair. To the chair.
I recognize myself for 5 minutes. I urge all of my colleagues to support H.R. 2570, the Climate Risk Disclosure Act, by Mr. Casten of Illinois. Currently, only a small percentage of companies report their exposure to climate risk, leaving investors without the critical information they need to make the best long-term investment decisions. According to a recent study, market prices for public company shares fail to factor in the potential cost of climate change and environmental exposure to the tune of trillions of dollars. exposing millions of hardworking families and retirees to enormous financial risk. At a hearing before the Investor Protection, Entrepreneurship, and Capital Markets Subcommittee this year, a representative for CalPERS highlighted the need of required disclosure by stating that, and I quote, investors need companies to provide a detailed explanation of how each significant climate-related risk affects the company, as well as disclosure of exactly how the company plans to address and manage the risks so they can evaluate the risk reward of their investments. End of quote. By requiring companies to disclose information relating to the financial and business risk associated with climate change, the market and investors can better assess the risk that global warming poses to public companies, help protect the financial futures of hardworking families, and incentivize companies to make critical changes to address climate change. So I urge my colleagues to join me in supporting our efforts to provide the market with critical information to help address climate change, and I yield back.
Madam Chair.
For what purpose does the gentleman from Arkansas seek recognition?
Madam Chair, I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed electronically. Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
Substitute amendment to the amendment in the nature of a substitute.
I move to dispense the reading of the amendment, Madam Chair.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. This amendment, again, follows up on the work that we've done with Mr. Casten and Mr. Vargas over the last few weeks. And while I support the idea that this could be done and done in the right way, I don't think that Mr. Vargas's approach or Mr. Casten's approach is the right course at this time. So my amendment replaces the underlying legislation with a study that must be conducted by the SEC to summarize and describe any inconsistencies related to climate risk by the many conflicting and different climate-related disclosure frameworks that are out there, some cited by Mr. Sherman, before mandating a specific disclosure from public companies, large or small. Not only is Mr. Casten's legislation extremely prescriptive, but the legislation, in my view, puts the cart before the horse. My amendment ensures that Congress and the Commission are being thoughtful and taking careful action before creating a new standard. As I've said many times before, the SEC, the markets, are a markets and financial regulator. They're not qualified to create or enforce climate metrics. This legislation is, in some ways, presumptive and prescriptive in how it would be measured, and one of the many reasons I have issues with the bill. Some of the more troubling positions requires companies to analyze the potential risks of the social cost of carbon, which includes things like any impact on human health or potential property damage. You've got to measure that and disclose it for your company. stating that it's a sense of Congress that climate change is the cause of violent extremism. Number 3, provide a quantitative analysis to support any qualitative statement made by the issuer, meaning that anytime a company puts information about their emissions into their annual filings, they have to conduct an outside analysis that backs that position up. And probably what's the most troubling is that the Task Force on Climate-Related Financial Disclosure backstop if the SEC doesn't act in 2 years. For those who aren't aware, the Task Force on Financial Disclosure was initiated by the Financial Stability Board under the leadership of Mark Carney, former governor of the Bank of England, to try to create standards for companies to measure and disclose climate risk. Mr. Carney appointed former Mayor Mike Bloomberg to head it, and Mike Bloomberg selected an oversight body with a majority membership of pro-climate, already paid climate disclosure activists and executives. So it shouldn't be any surprise that he got the outcome that he wanted out of the task force. And while the task force has a very well-intentioned set of discussions and ideas, their analytical work required to implement disclosures is difficult and costly, by their own admission. And the current cost may well exceed the benefits to the issuer and, more importantly, to our investors. Any implementation based on what we know today is significantly premature. Mandated imposition of these disclosures will misinform investors, drive up unproductive costs for issuers, lower earnings for investors, and increase, in my view, litigation risk. And we just look at this issue of GHG that was talked about. In other words, greenhouse gas emissions, which is one of the disclosed things, particularly in the power industry. Mr. Casten, quick question. Have you read the Task Force for Financial Disclosure report? And secondly, have you studied that particular issue about GHG discussion that Mr. Bloomberg laid out?
Sorry, I need to unmute myself. I have not read the details of the report, but I'm quite familiar with GHG disclosure, having spent a lot of time in my career calculating those values for other companies.
Thank you. Reclaiming my time. The report says that GHG emissions associated with investments are very hard to determine. And it goes on to say that they recommend not using it. They say a manager should use a weighted average carbon intensity metric that's still being developed. And that GHG is very difficult for some of the reasons that Mr. Huzanga outlined on level 1, 2, and 3. So before we mandate this, I think the kind of study that the SEC would do is very important to make sure that Congress gets this right, the Commission can get this right, and that it will come up with effective rules that are transparent, comparable across industries, and legally able to disclose and not increase the risk of confusion to investors or to companies or increase litigation risk. Yield back.
The gentleman from Illinois, Mr. Casten, is recognized for 5 minutes to strike the last word.
Thank you, and thank you for your proposed amendment, my friend from Arkansas. I'm going to urge opposition to the amendment and rejection, primarily because this would replace my bill and direct the SEC to do a study. We don't need to study, and the issues that you raised, they're legitimately complicated. I quite agree that calculating, when you buy electricity, should you look at the location-specific emissions? Should you look at the average emissions? Should you look at the hourly marginal emissions? Those are really complicated questions. But you know what? They've been asked and answered decades ago. I started my career as a consultant doing that many, many years ago. We don't need another study, but let's be very clear. We're not here at this point because we don't know what the problem is. We are not here at this point because we don't know what the solutions are. We're here at this point because people who knew precisely how damning this would be to their business pressed the information. ExxonMobil knew in 1981 that the world was warming, that the warming related with their products was going to be massively catastrophic. You can go back, you can look at their memos. They predicted pretty well where we would be right now, and they made an active effort to suppress that. If our grandchildren are going to be proud of us, they are not going to be proud of us because we did a study. They're going to be proud of us because we acted. It's high time that we provide investors and markets with standardized information that they need, that they have been clamoring for years. And with that, I urge rejection of this amendment. I yield back.
The gentleman yield for a question.
Yes.
Thank you. I just want to again go back to the task force report that Mayor Bloomberg chaired. I've studied it extensively and why it calls for the kinds of disclosures absolutely that you're talking about, but you've used it as a standard for your bill, meaning if the commission doesn't act, then ipso facto, we shall use the task force on financial climate disclosures as the basis for the disclosure, and the SEC will do that within by the end of 2 years. Let me just read you some comments from that report. Regarding the GHG, the greenhouse gas emission disclosure, the so-called Scope 1 disclosure that's used very consistently, as you note, by the power generation industry, for example. The gaps in emissions measurement methodologies, including Scope 3 emissions and product lifecycle emission methodologies, make reliable and accurate estimates difficult. Next point. The lack of robust and cost-effective tools to quantify the potential impact of climate-related risks and opportunities at the asset and the project level make aggregation across an organization's activity or an investment portfolio problematic, costly. The need to consider the variability of climate-related impacts across and within different sectors and markets further complicates the process, magnifies the cost of assessing climate-related impacts. And finally, the high degree of uncertainty around the timing and magnitude of climate-related risks makes it difficult to determine and disclose any potential impacts. So that's why I think the study to narrow this focus is the right approach, because many companies are out disclosing, as you know, materiality. They're already disclosing climate risk if they believe it material, and they're also doing a lot of supplemental disclosure. And the reason why it's variable, in my view, is that there isn't an agreed upon issue. So how do you mandate something that's not already agreed upon? And I yield back to my friend.
Well, so I think we've combined a couple things there, because you started with greenhouse gas emissions. And if you're talking about greenhouse gas emissions in the power sector, you're not talking about Scope 3 emissions. The international standards that are out there, it's appropriate for that to be a backstop, because there's a rich conversation going on internationally of recognizing not just difficulty of capturing Scope 3 emissions, but also making sure that if you buy power in Arkansas from someone in Oklahoma, that person in Oklahoma didn't double count the emissions that you're now taking credit for or penalty for. That's a rich conversation, and it needs to be done. But actually calculating your Scope 1, your Scope 2 emissions is very straightforward, and it's appropriate. It's not difficult. People have figured that out. Ultimately, we are going to have to harmonize with an international accounting system. But again, that work has been done. It seems strange to us on this committee only because the United States has chosen for 3 decades not to play a lead role in those conversations. But let me assure you, those conversations have happened, and we don't need to do more study at this point.
The gentleman yields back.
Yes, yield back.
I now recognize myself for 5 minutes. I urge members to reject this amendment. Members, we do not need more study on this issue. The industry has been discussing climate change accountability since at least 2000. We know that climate change is real, and it is time we act on that reality. This is not theory or part of a Democratic agenda. It is a fact. According to the Climate Disclosure Project, a coalition of bankers, fund managers, advocacy groups, and politicians, climate change will cost the 215 largest listed companies nearly $1 trillion over the next 5 years alone. This amendment, however, continues to push the false narrative that the SEC doesn't know what to do, that investors aren't sure what climate data they want, and companies would be harmed by disclosing their risk to climate change. Companies are increasingly disclosing this information because investors want it. What investors crave, however, is consistency, which only the SEC can provide. We know the science. It is far past time we provide investors and markets with the information they need to access the risks, the companies they are invested in face due to climate change. With that, I yield back the balance of my time. Is there further debate on the amendment?
Madam Chair, I move to strike the last word.
The gentleman from Michigan, Mr. Huizinga, is recognized for 5 minutes.
Thank you, Madam Chair. And before I yield some time to my friend from Arkansas, I hail from Michigan, the automotive capital of the world. And there's a lot of rich conversations that are happening about the future of the automobile and the future of transportation. So far, Congress has wisely not mandated things that are not technologically available or able to happen. That sadly is seemingly what the author is trying to do here. And it's like, don't worry about it. It'll all work itself out. Let's just plunge ahead. And in the meanwhile, we're going to use the hammer called the SEC to punish companies that don't do what we think it ought to do. And oh, by the way, we haven't given them the description of what we're asking them to do. So that puts everybody at an unfair situation. So with that, I'd like to yield to my friend from Arkansas.
I thank my friend from Michigan. And again, Madam Chair, no one is pushing a false narrative here. No one on the Republican side of the aisle is saying that there isn't the opportunity to have additional climate disclosure under some appropriate methodology for public companies. As you know, public companies that have significant aspects of climate risk that are material are already disclosing those. And others are disclosing non-required informational presentations on their website for background purposes about their climate strategy. They have many pages of that to try to be responsive. The reason why it's not consistent and comparable is because there's debate about that, just as there's debate in the scientific aspect of the impacts and how to measure them on a company basis or across companies, as I indicated in the Mike Bloomberg report, his concerns. That's true in the accounting and financial disclosure. But let's be clear, companies that have a material impact from climate-related risks are disclosing those in their 10K and their 10Q, and many other companies are disclosing voluntarily. And that's their obligation under current law. And the reason why it's not been done is it's not easy. And let me repeat also what Mike Bloomberg's task force said are the principles for an effective disclosure. Disclosure should represent relevant information. Disclosure should be specific and complete. I think that's challenging in my friend's proposal. Disclosure should be clear, balanced, and understandable. They're not. They're 5 or 6 competing consulting firms making money off public companies trying to determine which one is the best ESG metric. Disclosure should be consistent. They haven't been. Disclosure should be comparable among companies within a sector, industry, or portfolio. The data should be reliable, verifiable, and objective. Disclosure should be provided on a timely basis. And then the task force goes on to say cost-benefit analysis should be applied. And that's why we asked Gary Gensler, our new chair of the SEC, in any process for this, will he fully use the Administrative Procedures Act, and would he require a careful cost-benefit analysis of any proposal because of the challenging things that both Mr. Huizinga and Mr. Barr have raised? So let me say that this is not about a false narrative. Quite the contrary. This is about doing something right. And we're not studying emissions by power companies. We're now putting pen to paper on what we're going to mandate. American business is required to be disclosed, that whether or not it's material, and Mr. Casten presumes it's not material in some instances, doesn't have a materiality requirement, that there is litigation risk to these businesses, so that means it has to be consistent, documented, verifiable, and independent, or they're at risk of major litigation risk. If it's wrong, it could be very misleading to investors. So again, no false narrative. It's like taking the idea and let's do it right. We're not studying anything except what the disclosure ought to be among all the competing disclosures. And even Deloitte and Touche, one of the great public accounting firms in our country, says
that, it's not ready for prime time. They say it can't be done in some instances. So I appreciate my friend from Michigan yielding time, but I think Republicans want to get this issue right, consistent with the APA, consistent with cost-benefit analysis, and consistent with verifiable, relevant, and effective information for our investors. I yield back to Mr. Hazain.
Is there further debate on the amendment? If not, I will withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye. Those opposed, no. No.
No.
In the opinion of the chair, the noes have it. The noes have it, and the amendment is not agreed to.
Madam Chair, I request a recorded vote.
A recorded vote is requested. All in favor of recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion or amendments on the bill?
Madam Chair.
For what purpose does the gentleman from Kentucky seek recognition?
I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed electronically.
We're good.
Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HR 25.
I ask unanimous consent that the amendment. be
Without
considered
objection,
read.
the amendment will be considered as read. Gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. My amendment is simple. It states that any company that is subject to the Climate Risk Disclosure Act of 2021 is not required to make the disclosures discussed under the law unless there is a substantial likelihood that a reasonable shareholder would consider such information important with respect to making an investment decision. This is the Supreme Court's long-standing standard for disclosing material information and ensures that a public company that public company disclosures are in fact material to the average investor of the company. The seminal Supreme Court case that defines the materiality standard was TSC Industries versus Northway. In the majority opinion, Justice Thurgood Marshall wrote, quote, "If the standard of materiality is unnecessarily low, not only may the corporation and its management be subjected to liability for insignificant omissions or misstatements, but also management's fear of exposing itself to substantial liability may cause it simply to bury the shareholders in an avalanche of trivial information, a result that is hardly conducive to informed decision-making." Now, Mr. Casten, as much as admits the uncertainty and complexity of climate risk metrics in his colloquy with Mr. Hill, he talks about the difficulty of defining the scope of Scope 3 emissions. He admits that this is a complex issue, and if that is the case, we can expect to see these disclosure requirements coming out of this legislation to result in burying shareholders in an avalanche of trivial information. This is a common sense amendment. If the disclosure is not material to the company, why should the company have to disclose it? It seems wasteful and potentially confusing for investors who rightfully expect public companies to disclose information that is actually material to the company. I'm not opposed to voluntary climate change disclosures, not even opposed to mandatory climate change disclosures that are material for companies that actually pose or face climate risk, or material to a category of investors. But I cannot believe it is material to every investor or company, nor can I believe that every company should be required to make climate change disclosures using the same format, thanks to an SEC rulemaking bill that we are discussing today. All else being equal, companies have a finite number of dollars to allocate across their enterprise. The more dollars they allocate to compliance with ill-defined and overly broad reporting requirements, the fewer dollars they can allocate to research and development, employee training, sales, and marketing. The opportunity cost is immense, which is why we must ensure that any required disclosure meets the materiality standard and provides useful information to investors. My amendment right-sizes the expansive and burdensome disclosures under this bill. It will make clear that only companies for which climate change disclosure is actually necessary are the ones that have to make climate change disclosures. Companies for which the information under this bill will not likely be considered by a reasonable investor will then not make those disclosures. This common sense right-sizing will serve to save compliance costs and avoid confusion of investors. Finally, I would quibble with the idea that this is what the market wants, demands, or in fact needs. Instead, it is where this administration, perhaps this SEC, and certain members of Congress want to artificially steer the market with non-material, derogatory information about companies that are politically unfashionable. I think Mr. Casten, my friend from Illinois, used the word damning. I think that was exactly the verbatim word he used, damning information. That sounds to me more like naming and shaming and stigmatizing public companies rather than actually providing investors with material and accurate information that investors actually want. So with that, Madam Chair, I urge my colleagues to think clearly about this. Let's make sure that disclosures actually meet the test of the U.S. Supreme Court, that being materiality. Let's require disclosures only when they actually would inform investors. And I'll make one final point in my remaining time, and that is a general comment about ESG investing. And this is from a recent article about the popularity and the materiality of these ESG investments, that it could be quite an accident because many ESG funds invest heavily in tech companies, and tech most likely is a rallying for reasons that have nothing to do with ESG. Many ESG funds exclude fossil investments, but fossil investments could be doing poorly for reasons that have nothing to do with ESG. Look closely, and it appears that ESG is not just another old-fashioned stock market bubble. With that, I yield back.
Is there further debate on the amendment? I will now recognize myself for 5 minutes. I urge members to reject this amendment. This amendment seeks to impose a materiality standard for information we already know is material. As we learn more about the potentially devastating impacts of climate change and the equally devastating impact of a company's failure to mitigate climate risk, it would be nothing less than derelict if we failed to consider that information material. Supply chain disruptions from climate change can increase the cost or lower the quality or quantity of available supplies. Rising sea levels can result in a property damage or operational disruptions. Climate change is causing increased insurance claims, premiums, and deductibles. And all of these things impact shareholder value. This is why many companies are already disclosing this information. We know this information is material, but unfortunately, not all companies are providing this information. The markets need clarity, which is precisely what Congress can do by passing this bill. So I urge members to reject the Barr Amendment and support H.R. 2570, and I yield back the balance of my time. The gentleman from Illinois, Mr. Casten, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair, and thank you for your kind words and support. I also encourage rejection of this amendment. What my friend Mr. Barr is proposing is that a covered issuer would only need to disclose the information if there's a likelihood that a reasonable investor would consider the disclosure important. That's what's in the current law, and it's already proven insufficient. So this would basically make the bill irrelevant, revert to the current system that's in place, which, let's be honest, is not working. I reject the idea that you can't have a common standard. We do that for accounting. There's a whole lot of complicated issues in accounting, from revenue recognition to balance sheet consolidation to intercompany transfers. And yet every company, big, large, and small, that wants to have an audited set of financial records agrees that they have a consistent set of standards. And I don't think any business long survives that avoids hard problems. But I want to go to a larger conversation about this discussion about materiality. I ran a private equity-backed company. I can't imagine any scenario where my investors would have asked me for data about the company that they had invested in, and I said, you are not allowed to have that information because it's not material. That would have been a fairly short conversation. The difference between a private company and a public company is the sophistication of the investors. Had we taken that company public, I would have gone from one large investor to a lot of small, much less sophisticated investors. It is the SEC's job to protect those investors. And those investors, by definition, are not going to have the kind of sophistication that you might have in a big private equity-backed company, as I had. But look at what the big players in this space are saying. Larry Fink, BlackRock CEO, kind of a big retail investor. He described climate change in his January 2020 CEO letter as, quote, a defining factor in companies' long-term prospects, and said, climate risk is investment risk. That sure sounds material to me. Look at the $37 trillion of retail investors who are moving into ESG funds, and the fact that those funds don't provide correlated results. I agree with Mr. Hill when he said there's 5 to 6 competing standards. That's the problem. And what this bill does is fix it. It provides a consistent standard like we do for accounting. It is material because the big sophisticated investors are all telling this is material, because the physics is telling us this is material. And it's time for us to move forward, and I urge rejection. Thank you, and I yield back.
Is there further debate on the amendment?
Mr. Stile.
If not,
Mr. Stile from Wisconsin.
Oh, Mr. Stile is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I'll keep this quite brief. I just think it's quite relevant. We're talking about materiality. It was noted in previous remarks that there is material information that's not being disclosed. If so, that would likely be a security law violation. Would love to see the evidence of said securities law violation be something that maybe we could look into. But I think what we're actually seeing is publicly traded companies who are not providing non-material information. They're providing material information. And I think we are hearing kind of cavalier comments regarding public companies, their ability to follow current securities law. If the information is material and it is not disclosed, we should be presented with that evidence, because that'd be a securities law violation. Otherwise, the evidence would suggest that companies are not failing to disclose material information. I just think it's a relevant point for us to keep in mind. And I will hold there and yield to my good friend from Kentucky, Mr. Barr.
Thank you. One comment in response to my friend from Illinois. It strikes me as shocking, frankly, that we're talking about dispensing entirely with a materiality requirement and divining, if you will, from Congress what we think is material, as opposed to actually, and requiring, by not having a materiality requirement, requiring the disclosure of non-material, irrelevant information and burdening investors with a whole lot of trivial and unrelated information. This strikes exactly at the heart of what Thurgood Marshall said we shouldn't be doing. We're going to be hurting investors because we're going to be giving them a whole bunch of non-material information, or at least information that Congress deems to be just automatically material, but actually isn't. And so I think that this is an issue of investor protection. I think burdening investors with this, as Justice Marshall correctly described, an avalanche of trivial information that many investors, frankly, don't understand and don't care about. And look, I fully admit that there are some woke investors in this country, including Mr. Fink. And he's a big investor, admittedly. He cares about this stuff. There's a lot of mom and pop retail investors who depend on returns, for their retirement, for their college savings, and they want maximum returns. They don't want high ESG fees. They don't want some green woke result. They want returns. And the idea that we're going to burden these investors, these retail investors, with all of this information and push them into high fee products and compromise their returns into fad products that may or may not actually be ESG because we don't have accurate information or definition of it, and could actually ultimately, because of the article that I cited, actually result in a stock market bubble and hurt the investor. I think this is a real problem. Materiality should be the North Star for investor protection, and to simply brush it off as not important is, I think, a massive disservice to Main Street retail investors in our country who demand materiality as part of their investor decisions. And with that, I yield back.
I appreciate my colleagues' passion to protect mom and pop investors, people trying to save for their retirement, save for their kids' education, and to push back against my colleagues across the aisle that simply want to place more regulatory burdens on U.S. companies, making us less competitive with countries such as communist China. And I'll pause there and yield back.
Is there further debate on the amendment? If not, I will withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye. Aye. Those opposed, no. No. In the opinion of the chair, the noes have it. The noes have it, and the amendment is not agreed to. A recorded vote has been requested. All in favor of a recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion of our amendment to the bill? Okay. If there are no further amendments without objection, the previous question is ordered on HR 2570. Is that 10 or 17?
2570, that's correct. You said it correct.
And pursuant to Section C5 of Committee Rule 3, further proceedings on the pending amendments are postponed.
Why don't they tell you amendments?
Pursuant to notice, the chair now calls up H.R. 1188, the Greater Accountability in Pay Act. The clerk will report the bill.
H.R. 1188, a bill to amend the Security Exchange Act of 1934 to require issuers to disclose information.
Without objection, the first reading of H.R. 1188 is dispensed with. The gentlewoman from New York, Ms. Velázquez, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and are also on the dais. The clerk will read the amendment.
Amendment in the nature of a substitute to H.R. 1188 offered by Ms. Velázquez.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentlewoman from New York for 5 minutes to explain the bill and her amendment.
Thank you, Madam Chair. When we passed Dodd-Frank, we included the requirement that publicly traded companies provide information comparing the annual compensation of their CEOs to their employees. The Greater Accountability in Pay Act of 2021 is the next logical step of that requirement. My bill requires publicly traded companies to disclose the pay raise percentage of its executives and the pay raise percentage of its median employees over the past year and compare each to the rate of inflation. It also requires public companies to disclose the ratio between the pay raise percentages. The COVID-19 pandemic has left millions of working-class Americans feeling vulnerable and uncertain about their economic future, with many individuals and families facing reduced hours, furloughs, or outright dismissals. However, a recent article published by the New York Times entitled CEO, Pay Remains Stratospheric Even at Companies Battered by Pandemic, demonstrates the extraordinarily successful year it's been financially for America's biggest CEOs, even at many of the companies hit hardest by the events of the pandemic. For example, the article highlights that Norwegian Cruise Line paid its CEO, Frank Del Rio, $36.4 million, despite the company losing $4 billion and furloughing 20% of its staff. And Hilton, which lost $720 million and laid off a quarter of its corporate staff, rewarded its CEO, Chris Nassetta, with a compensation package worth $55.9 million. Unfortunately, excessive compensation packages received by many of America's CEOs is not a new or isolated event. The disparity between executive compensation and the average worker pay has been growing for decades. A study produced by the Economic Policy Institute in August 2019 highlights that even before the pandemic, CEOs were earning far more than the typical worker, with CEO pay growing 940% between 1978 and 2018, while the wages for the typical worker grew by just 11.9% over that same period. CEO pay isn't increasing because public companies are becoming more profitable or becoming more valuable either. In fact, the EPI report demonstrates that while CEO compensation grew 940% between 1978 and 2018, the S&P grew by only 706.7%. CEOs are getting paid more because of their power and their ability to set their own pay, not because they are increasing productivity or possess specific high-demand skills. Moreover, exorbitant CEO pay is a major contributor to rising wealth inequality, which can be highly destabilizing for industrialized economies. Finally, additional transparency on pay ratios will benefit investors, as data is key to their decision-making process. A balanced pay ratio is an indicator of a company's strong long-term performance, and further pay ratio disclosures will provide better insight on a company's strategy, its values, and long-term outlook. I want to thank Chair Waters for her support for this bill and including it in today's markup. I urge my colleagues to vote yes on this bill.
Thank you. Is there further discussion of our Amendment 2, the amendment in the nature of a substitute? The gentleman from Wisconsin's Mr. Stile is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed electronically.
Yeah, I mean, she sent it. I think she sent it. She did, like, Braden sent it at 1:43. And I think she sent it too. I don't know. Yeah, I don't. She sent it at 1:43 to FSC Docs. And I think Katrina sent it too. I'm not sure. Yeah, I don't know. We still don't have it yet. It's like, what, 6 minutes now?
FYI, whoever's on the microphone, you're not muted. Just wanted to let you know.
Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
An amendment to the amendment in the nature of a substitute to HR
I seek
1188.
unanimous consent the amendment be considered as read.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain the amendment.
Thank you, Madam Chairwoman. I can promise to everybody on the committee that these 41-word, they were worth the wait. This is a pretty good amendment. I'm looking forward to this just being unanimously approved. You can find it. It's only 41 words. It's an easy read, but I'll give you a quick summary of it to bring everybody in this room across the line in support of the amendment. It's pretty straightforward. It states that any company that is subject to the underlying bill will not be required to make the additional mandatory disclosures required by the bill unless there is a substantial likelihood that a reasonable shareholder would consider the disclosures important in making an investment decision. The amendment, to me, just makes sense. The disclosures required under this bill do not consider a company's geographic location. The bill doesn't consider the product or service that a particular company offers. The bill doesn't consider any of the numerous additional factors that are often tied to compensation figures used for calculating the pay-raise ratio. Like the Dodd-Frank pay ratio disclosure, the disclosure in general paints a incomplete and often misleading picture for everyday investors. And so my amendment ensures a company will only have to disclose the information if it's material to the average investor. That means a company will have to disclose it if it provides useful information to everyday investors, such that they can easily compare different companies by making informed investment decisions. Most importantly, this amendment ensures that the materiality standard, a touchstone of our public company disclosure regime, is maintained. It ensures that everyday investors will not find themselves overwhelmed with additional mandatory disclosures that are not material. I urge my colleagues to support this straightforward 41-word amendment. I think it's common sense, and I encourage your consideration. With that, Madam Chair, I yield back.
Madam Chair,
Who seeks recognition?
Ms. Velázquez.
Congresswoman Velázquez,
I move to-
recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. I speak in opposition to this amendment. All public companies are required to file periodic and annual reports with the SEC disclosing certain business and financial information about the company.
Yes.
The purpose of these reports is to provide investors with the information they need to make informed investment and voting decisions. As we have talked about, robust disclosure helps to mitigate significant information irregularities between management of a company and shareholders, enable shareholders to hold managers accountable, and to make consistent cross-company comparisons, enhances the accuracy of stock prices, and make more informed decisions, leading to a more efficient allocation of capital. And I think it is pretty clear that shareholders and investors have already decided that this information on pay is material. Investors have been demanding more and better disclosure of ESG and corporate governance information from public companies. For example, a report by Donnelly Financial Solutions in November 2018 found that 95% of institutional investors often or always consider governance issues for all investment. Moreover, the New York Times story I mentioned in my opening statement pretty clearly demonstrates that CEO pay, particularly over the last year, is completely divorced from company fundamentals. I think a maximum profit-seeking investor considering investing in Hilton will want to know that Hilton lost $720 million and lay off a quarter of its corporate staff last year, but still got paid $56 million. Do you try to tell me that an average ordinary person saving for his retirement do not want to know that while Hilton was losing money, that the CEO got almost $56 million? And it is not just Hilton. Boeing, Norwegian Cruise Line, and AT&T took billions of dollars in losses in 2020, but still all managed to pay their CEOs more than $20 million. This dynamic raised serious questions about corporate strategies, values, and long-term outlook in all of these corporations. This is exactly the type of information investors rely on to make their decisions. The more information they have, the better informed their analysis will be. But more importantly, materiality misses the point of these disclosures. Income inequality is widening. Income inequality in the United States has risen dramatically since the late 1970s by shifting an even larger share of income to rich households that save rather than spend. Some economists estimate that this rise in income inequality has slowed growth in aggregate demand by 2 to 4 percentage points of GDP annually in recent years. In order to increase aggregate demand and get our economy back on track for everyone, we must increase worker pay and ensure that CEO pay ratios are in line with a corporation fundamentals. That is what the bill is designed to help to do.
Thank you.
I yield back.
The gentleman from Texas, Mr. Green, is recognized for 5 minutes.
Thank you, Madam Chair. I appreciate what my colleague is attempting to do, but in a way that I'm in agreement with.
Mr. Green, are you speaking into the microphone?
Let me move closer. Thank you, Madam Chair. Can you hear me now?
Yes, I can hear you better.
Thank you very much. Madam Chair, I'm opposed to the amendment because the materiality of this is quite evident. Ms. Velázquez has made that very clear. But what this really does is it places the burden on the investor to file a lawsuit when the company declines to disclose. This puts a great burden on the person who desires to invest, as an investment, competing with the battery of lawyers that the company will have will be almost impossible for an investor. Some may be able to do it, but most will not. And this only prolongs the time within which one might find out what might get the information, but it also makes it almost impossible to get the information. So I would oppose it, and I yield.
Is there further debate on the amendment? I now recognize myself for 5 minutes. I stand with workers to strongly oppose this amendment. While compensation of corporate executives have continued to rise, median worker wages have remained stagnant. In fact, a recent Pew Research study, that is the Pew Research Center study, shows that today's real average wage has about the same purchasing power as it did 40 years ago. Meanwhile, compensation for companies, CEOs, continues to skyrocket. According to an analysis performed by the Economic Policy Institute in 1965, the average CEO was paid 20 times the average worker. By 2017, the average CEO compensation was 312 times that of the average worker. There is a substantial body of research that shows direct correlations between out-of-balance pay ratios and a number of poor performance indicators. It is crucial that we stand up for our nation's workers and provide investors the information they need to assess certain corporate CEOs, whether corporate CEOs are focused on growing the company they have been tasked to lead by investing in its workers, or if they are focused on enriching themselves at the expense of the company, its workers, and its shareholders. Mr. Stiles' amendment would maintain the status quo and gut the important transparency surrounding compensation disparities at public companies that Ms. Velázquez's bill would provide. So I urge members to reject this amendment. I stand with America's workers and oppose this amendment. I also stand with investors who require this information to make sound and informed investment decisions. To be clear, we're not suggesting we dispense with the concept of materiality. However, the information that meets that standard has vastly evolved, and disclosure requirements must evolve with it. Also, where some companies are not disclosing the information or are disclosing it differently, instead of suggesting enforcement action against those companies, as my Republican colleague proposed earlier, we are suggesting giving all public companies clarity. At its core, this bill is about human capital, management and human capital management is material to investors. During the pandemic, American workers were laid off in record numbers. We're taking new positions, sometimes with substantial pay cuts, and essential workers were risking their health and safety to stay employed. Still, CEOs received exorbitant compensation packages, and in some cases, pay raises. In fact, CEO pay reportedly hit a record high in 2020, laying off hundreds of workers who contribute to the company's operations while handing the CEO a pay raise. It is evidence of a company mismanaging its most vital asset, its workers. This sort of human capital mismanagement can affect productivity, which in turn impacts shareholder value. So even if shareholder value was the only metric for materiality, which I do not believe it is, this information must be deemed material even under my Republican colleagues' own standards. So I urge members to reject the style amendment, and I yield back the balance of my time. Is there further debate on the amendment? If further debate, if not, I withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye.
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 Those opposed, no.
No.
In the opinion of the chairs, the noes have it.
Madam Chair.
And the noes have it, and the amendment is not agreed to.
Madam Chair, I request a recorded vote.
A recorded vote has been requested. All in favor of a recorded vote shall raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion of or amendment to the bill? For what purpose does the gentleman from Michigan seek recognition?
Madam Chair, I have an amendment at the desk.
We will pause to allow copies of the amendment to be distributed electronically. Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
amendment to the amendment in the nature of a substitute to HR 1188 offered by Mr. Huizenga of
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain the amendment.
Thank you, Madam Chair. And what we see here in this next bill is, in this current bill, my Democrat colleagues continue to try to use our securities laws to obtain certain political and societal objectives that more clearly and appropriately fall within the jurisdiction of other committees. This is evident by the mandatory disclosure requirements included in Dodd-Frank on conflict minerals, mine safety, resource extraction. We see it in each markup, it seems, and today is no exception. HR 1188 builds on the Dodd-Frank pay ratio disclosure. My amendment will simply repeal these 3 mandatory disclosure requirements, as well as the CEO pay ratio disclosure. These requirements do nothing to further the SEC mission or provide everyday investors with material information that is useful for investment decisions. We've had a lot of discussion on materiality and what is material information. And I feel like the other side sort of has a definition of materiality, much like they have a definition of infrastructure. It's whatever they need it to be at the time. So what we are really trying to get at, though, is enforcement of things within the SEC mission scope. And I've long discussed the impact of conflict minerals disclosure and its inability to help achieve the policy objective that we all agree on. The objectives of this disclosure harmed African miners by effectively killing the mining industry in the area, leading to devastating and unintended job loss. Don't take my word for it. Those of us that have served on the committee remember the hearings that we had on this. The Minister of Mines from Rwanda was here, testimony from Ugandans who were affected and impacted by this. This isn't affecting Americans, it's affecting Africans. So this disclosure requirement has also been expensive. Even Democrat estimates are over $7 billion. So these Dodd-Frank provisions are part of a continuing trend of using the securities laws to amend certain disclosures to push, frankly, a left-wing political agenda. This sets a dangerous precedent. Just last month, my Democrat colleagues pushed through a number of additional mandatory disclosure requirements on undefined environmental, social, and corporate governance issues, as well as political spending. It begs the question, do Democrats believe there are any bounds to the use of the Securities and Exchange Commission in their pursuit of shaping society? It doesn't appear that way. So we know that companies are already required to disclose information that is actually material to those companies. We just had this interaction with Mr. Hill and Mr. Casten on that bill. Democrats know that investment-related material information isn't enough to name and shame companies into acting in their preferred manner. So instead, we get the disclosures that my amendment seeks to repeal. To be clear, committee Democrats are seeking to expand the jurisdiction of the Securities and Exchange Commission, thereby diverting the commission away from its core mission and discarding our traditional securities law principles that have been in place for nearly 8 decades, written, by the way, from somebody from Michigan, Arthur Vandenberg, Senator Vandenberg. Congress should not be adding to the already robust disclosure requirements for public companies, as it will only make it more difficult for investors to find material information. Mr. Barr talked about what was said by Thurgood Marshall in the 1976 Supreme Court ruling. So by doing so, these additional disclosures may actually harm investors rather than protect and reduce our companies' public companies' ability to innovate, grow, and create jobs. If you oppose this amendment, it would seem that you are saying the SEC should force certain information into disclosures to accomplish political objectives, not investment objectives, and not an objective to protect investors. Former chair of the Securities and Exchange Commission, Mary Jo White, said it best, quote, "The Commission's independence allows the agency the freedom to do what it believes is right for investors and our markets without the interference of politics or outside pressures," close quote. We're seeing the waning days of that, former Chair White. I hope that we can come to our senses here. So with that, I urge my colleagues to continue in this manner and vote yes on this amendment. This ensures that the Commission can focus on its mission to protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. With that, I yield back the balance of my time.
Is there further debate on the amendment?
Madam Chair, I move to strike the last word.
The gentlewoman from New York, Ms. Velázquez, is recognized for 5 minutes.
Thank you, and I rise in opposition to this amendment. This amendment got the entirety of my bill and important provisions of Dodd-Frank. And I appreciate the concerns of Mr. Hazinga with mining or minerals extraction in Uganda and Rwanda, but that has nothing to do with my bill. So every time my colleagues on the other side of the aisle have to talk about CEO pay, they try to change the subject. And as I mentioned, conflict minerals have nothing to do with this bill. And it is pretty clear that the Dodd-Frank disclosures are working and that we need to expand them. And with that, I yield back. Thank you.
Is there further debate on the amendment? I now recognize myself for 5 minutes. I urge all members to reject this amendment. The Huizenga Amendment would not only strike the language Ms. Velázquez has put forward to address income inequality at public companies, it also strikes several important disclosures Congress passed more than a decade ago. When we debated Mr. Casten's bill, Republicans claimed they were protecting mom and pop investors from having to know whether a company was in fact at risk because of global warming. Now it seems my Republican colleagues want to protect mom and pop investors from knowing that a public company uses conflict minerals that are often mined using slavery in the Congo. And they want to protect them from knowing whether an oil company made bribes and other payments to a foreign country to access the country's oil reserves. They also want to keep quiet mining company failures regarding mine worker safety. Who precisely are the Republicans trying to protect? What is worse is that even though my Republican colleagues tried to argue that Ms. Velázquez's bill is not necessary because of existing Dodd-Frank disclosures, now they're trying to repeal the CEO pay ratio itself. Members, the underlying bill provides shareholders with information to better inform them about which companies truly value their human capital and their workers, while Democrats are proposing legislation that stands up for workers, address pay disparities, and provide investors with better, clearer information. Republicans are once again trying to undo Dodd-Frank and reforms that Congress passed 11 years ago. So I'm asking you to please vote no and reject this amendment. I yield back the balance of my time. Is there further debate on the amendment? If not, I withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye. Those opposed, no.
No.
No. In the opinion of the chair, the noes have it. The noes have it, and the amendment is not agreed
Madam Chair, I
to.
request a recorded vote.
A recorded vote has been requested. All in favor of a recorded vote should raise their hand and be counted. There's a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion of our amendment to the bill? And I recognize myself for 5 minutes. Is that what we're doing? To speak in support of H.R. 1188, the Greater Accountability Act by Ms. Velázquez of New York. This bill would help address an ever-growing trend in our nation, income inequality. One major factor to this trend is that while corporate executives and CEOs receive yearly bonuses and salary increases, rank-and-file workers do not. As a result, workers' salaries are not keeping pace with inflation. For example, according to data from the Economic Policy Institute, the typical worker is received just a 0.3% raise, but the average CEO from one of the 350 largest firms received a 17.6% raise in 2017. HR 1188 would shine a light on this issue by requiring public companies to disclose the pay raise percentage of their executives and the pay raise percentage of the median compensation of all employees over the past year and compare each to the rate of inflation. The bill would also require public companies to disclose the rate ratio between the two pay raise percentages. I thank Representative Velázquez for her work in crafting this important bill to support our nation's workers, and I urge my colleagues to join me in supporting H.R. 1188. If there are no further amendments, without objection, the previous question is ordered on H.R. 1188 and pursuant to Section C5 of Committee Rule 3, further proceedings on the pending amendments are postponed. Pursuant to notice, the chair now calls up H.R. 3007, the Disclosure of Tax Havens and Offshoring Act. The clerk will report the bill.
H.R. 3007, a bill to amend the Security Act of 1934 to require country-by-country reporting.
Without objection, the first reading of H.R. 3007 is dispensed with. The gentlewoman from Iowa, Ms. Axne, the sponsor of the bill, has an amendment in the nature of a substitute, copies of which have been distributed in advance to all members and are also on the dais. The clerk will read the amendment.
An amendment in the nature of a substitute to H.R. 3007 offered by Ms.
Without objection, the amendment in the nature of a substitute will be considered as read and considered base text for purposes of further amendment. I now recognize the gentlewoman from Iowa for 5 minutes to explain the bill and her amendments.
Thank you, Chairwoman. In 2018, U.S. corporations booked nearly $100 billion in profits in Bermuda, despite having only 740 employees there. Let me spare you all the math. That's over $130 million per employee. And you see the same thing around the world, from the Cayman Islands to Luxembourg. And, you know, I truly mean no slight to Bermudans, but that's not just because the workers there are more efficient and effective than other workers here in America. I don't believe that they are 2,000 times more profitable than Americans are. It's truly because multinational corporations are able to shift their profits to countries with low or even no corporate income tax, regardless of whether they have significant actual operations there. Meanwhile, investors and the public have no consistent information about which corporations are using loopholes and what countries they're booking their profits in. We are all aware of discussions around potential changes to how foreign operations of U.S. companies are taxed. And while those are not in this committee's jurisdiction, it's clear that those would affect the profits of multinational corporations. And it's also clear that changes that Barbados or the Caymans make to their tax laws would impact profits on their corporations that booked $60 billion in profit there. And those are changes that the U.S. investors have literally no say over. So that's why I've introduced the Disclosure of Tax Havens and Offshoring Act, to give investors the consistent, comparable information that they need to understand the risks of investing in U.S. multinational corporations. And keep in mind, these are public corporations with annual revenues of $850 million or more. This bill requires basic information about a corporation's operations on a country-by-country basis, which includes things like revenue, profit, taxes paid, tangible assets, and employees. Now, I know some of my colleagues are concerned about the burden, as they say, that this might place on public companies. And I'm happy to tell you this will not be a burden at all. The way we even know how much in total is booked in these countries is because of a 2012 agreement that requires large companies, those with more than $850 million in annual revenue, to disclose the information to the IRS. So my bill simply requires that information made public for the same large corporations that are already doing it. And since corporations are already preparing this information, this would require minimal work. You know, we all know that shifting profits to tax havens so that you can reduce taxes is not a long-term growth strategy. And investors definitely want this information so that they can identify which companies are planning and investing in long-term growth. One of the reasons they want to know are cases like the one Facebook is fighting, where they're in court with the IRS over $9 billion, or when the EU is seeking $15 billion of unpaid taxes from Apple. Those are obvious risks for shareholders and those companies. And we should all understand these tax evasion strategies also disadvantage our small businesses, which is a big concern. The Main Street small businesses in my district don't have offshore entities, and I'm sure that's the same for all of you. And that's why this is supported by small business groups, and I'm thrilled to see that. Chairwoman, I'd like to submit to you now 3 letters of support for the record. We've got first from 96 advocacy groups and NGOs, including the NAACP, AFL-CIO, and National Organization of Women. Second, from 3 small business groups, and finally, a letter from investors managing more than $2.8 trillion in assets.
Without objection, such is the order.
None of us here think that multinational corporations avoiding $60 billion a year in taxes is a good outcome. But for too long, the public and the investors have lacked the information that they need to know which companies are taking these risks to squeeze out extra profits. My bill would give those investors the information and would do so with minimal burden on companies. I urge a yes vote, and I yield back the balance of my time.
Further discussion of our Amendment 2?
Madam Chair, parliamentary inquiry.
The gentleman from Michigan, Mr. Huizinga, is recognized for 5 minutes to strike the last word.
Parliamentary inquiry, actually, rather than striking the last word.
Recognized to state his parliamentary.
I'm sorry. Query? You're recognized.
Thank you, Madam Chair. It seems to me that while this bill is yet another mandatory disclosure bill, which has been acknowledged, it has long-term implications on U.S. businesses and tax reporting, and I'd like to know if the committee or the bill's author consulted with the Ways and Means Committee, the committee with actual jurisdiction over tax policy, when drafting this bill.
This committee has jurisdiction, and this bill is being offered based on the fact that we have jurisdiction.
Well, Madam Chair, I and committee Republicans have a number of concerns with this bill. So we actually reached out to the Ways and Means Committee last week, and they have concerns. First, the IRS has rules in place from 2016 directing country-by-country reporting. IRS representatives disclose this information when necessary. I repeat that again. This information is already disclosed by the IRS on a case-by-case scenario. The bill upends that structure, replacing the IRS with the Securities and Exchange Commission. Ways and Means Committee Republicans are concerned that a company cannot protect its confidential business information under this mandatory disclosure framework, and competitors can potentially access confidential information under this bill. They were also concerned by the lack of context for reporting and the very real fear that public country-by-country data could drive suboptimal business decisions on that. So, Madam Chair, until these concerns are addressed, I would contend that it's premature to consider this bill.
Gentleman has not stated a proper parliamentary inquiry because the gentleman's statement constitutes debate.
Well, Madam Chair, okay. Let me make that more succinct. Madam Chair, under what authority are we considering this bill other than just saying we have jurisdiction when it clearly is in the jurisdiction of the Ways and Means Committee?
Jurisdiction, as I stated, is sufficient. We will now move on. The gentleman's inquiry is not proper.
Madam Chair, if I could make a quick statement, I'm reminded of one of my mentors, John Dingle, who said, we have jurisdiction in Ways and Means Committee because every bill is in jurisdiction of Ways and Means. So if we are replacing Ways and Means, I'm curious if that is going to be official policy or if this is just your policy.
The gentlewoman has ruled that the parliamentary inquiry is not acceptable. We have jurisdiction because this amends the security laws. The chair has ruled. Are there any further amendments to the bill?
Madam Chairwoman,
Who seeks recognition? Mr. Style, you're recognized for 5 minutes.
I have an amendment at the desk.
We will pause for the electronic distribution. Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 3007.
Madam Chair, I ask unanimous consent the amendment be considered as read.
Without objection, the amendment will be considered as read. Gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chairwoman. My amendment is straightforward. It brings this bill back within the zone of providing useful information to investors. This is about focusing on average investors rather than activists. My amendment will require companies to make the disclosure outlined in the bill only if there's a substantial likelihood that a reasonable shareholder would consider such information important with respect to making an investment decision. This is simple. It's a straightforward concept of materiality. I talk about this at pretty much nearly every markup, but I didn't invent this simple notion. This is the standard for material information set forth by the Supreme Court and followed by market participants for decades. Materiality is rightly regarded as one of the touchstone principles of our securities law. Yet today, my colleagues on the other side of the aisle want to abandon this standard. My concern is advocates of this bill want to invite misguided and misinformed activist scrutiny to pressure companies to conform to social agendas. This isn't what our securities law is for.
Will the gentleman suspend?
Yes?
Could you please put your mask on?
Parliamentary inquiry, Madam Chair?
You're recognized.
Under under the decorum of the House, we're allowed to remove our mask when speaking briefly at the microphone. My understanding is that the rules of this committee are such that we follow the decorum on the House floor. Is that not correct?
The gentlelady discussed the decorum of this committee when the committee first opened today, and we indicated that we consider this a decorum question. So would the gentleman please keep the mask on?
But purely on a parliamentary inquiry, are we following different rules than the guidance from the attending physician and the guidance as put forward in the House?
We are following the rules of the attending physician. Yes, we are. The gentleman may proceed and continue with his amendment.
I will continue. So going back, so what I challenge my colleagues, if this bill is truly about helping investors to make more informed investment decisions to get a financial return, how does the materiality standard fall short? A vote for my amendment is a vote for empowering shareholders and bolstering the tried and true principle of materiality. Anything else is simply a vote to weaponize our securities law for social engineering, for name and shaming, for additional regulatory burdens. And I encourage a yes vote on my amendment. And with that, Madam Chair, I yield back.
Is there further debate on the amendment?
Yes,
Madam,
Mr. Davidson is recognized for 5 minutes to strike the last word.
Thank you, Madam Chairwoman. I do move to strike the last word. As I've said before, if we do not uphold the materiality standard, what comes next could be frightening for public companies. An overly broad ESG disclosure regime would arm nanny state activists with the ability to distort information and use it as a basis to force companies to operate in accordance with the DNC's political principles and not the financial best interest of shareholders. This would essentially force company directors to be walking on eggshells each time they have to make important business decisions. Additionally, the fiduciary duty of care and loyalty that directors have towards their companies and its shareholders are set by state law, and they would be slowly eroded as this new disclosure regime would make companies answerable to stakeholders with political priorities rather than the shareholders of the company. So as Mr. Stile has stated, a vote for this amendment is a vote for empowering its shareholders. I'd also add that a vote for this amendment ensures that we reinforce our capital markets framework that allows our markets here in the United States of America to become the most robust capital markets in the world. With only about 5% of the world's population, we have nearly 25% of the globe's GDP, and we have roughly 50% of the capital markets. So I think we should stop tinkering with things and undoing the duty of fiduciaries with these politically motivated disclosure regimes. And I yield to Mr. Stile, if he likes.
Is there further debate on the amendment?
Madam Chair, I yield to Mr. Stile.
I believe the time has been yielded, Madam Chair, if I may.
Yes.
Thank you. I appreciate my colleague, Mr. Davidson's remarks. I think it is really an important aspect here. We've discussed it pretty significantly today. We discussed it at almost every hearing or markup that we have here. There's a real significant drift away from the materiality standard by many of the bills put forward by our colleagues across the aisle. I think it's really a dangerous step as it relates to both securities law, but also to the efficiencies of our markets. And Mr. Davidson, I think, correctly indicated and pointed out the size and scale of the U.S. capital markets. The strength of the U.S. capital markets relies on a regulatory regime that is thoughtful, that is targeted, that is efficient, that actually addresses the concerns of the average investor, not what is in the political interests of the party in power in Washington at a given period of time. And so I remain concerned about this drift away from the materiality standard as it relates to our securities law. I remain concerned about those that try to use our securities law to put forward a social agenda unrelated to the underlying investment risks that we're seeing. And so this amendment, like previous amendments that I've offered here, simply puts back in place that cornerstone principle of materiality, which I think is so essential to our securities law. And I yield back to my colleague, Mr. Davidson.
I thank the gentleman for his
Gentlewoman from
amendment
Iowa,
and
Ms. Axne, is recognized for 5 minutes to strike.
reclaiming my time, Madam Chairwoman. I wanted to thank the gentleman for the amendment and really the work that's gone on to make materiality such a focus in our committee on a consistent basis. We all have priorities here politically, and I just think that we should find common ground in seeing our markets flourish. And the sad reality is we see novel innovations that are inherent in all markets, but a lot of our innovations in our markets are regulatory arbitrage. You've seen the expansion of things like SPACs that do need our attention in short order, but it's because we've made the existing disclosure regimes so overbearing. So we have the chance to make our markets better and more efficient. This goes in the wrong direction, and now I do yield.
Does the gentleman yield back?
As I said, I now yield.
The gentlewoman from Iowa, Ms. Axne, is recognized for 5 minutes to strike the last word.
You know, I simply fail to understand the point of this amendment. All this does is throw up another roadblock in getting information out to investors. And I know that when the SEC issues rules about this, they'll be listening carefully, to the investors and asking for input, just as like they always do. And there's a big flaw in how the materiality standard my colleagues like to talk about so much actually works in practice. It literally leaves companies, not investors, getting to make all the decisions about what to disclose. And all too often, they're choosing not to disclose the things that many investors actually want and need. And as a matter of fact, I'd like to point out that the Business Roundtable, which is made up of basically all of the largest companies in the world, wrote about last summer that companies are committed to all of their stakeholders, including employees, the local community, and not just shareholders, that they want to see the connection there of bringing transparency out so that all the folks that they serve have an opportunity to see that. So let's get back to this. Even when companies don't disclose it, they often aren't providing consistent, comparable information. It's the reason that we require all public companies to disclose their earnings and that we standardize those and how they're measured. Meanwhile, we all hear from companies who are upset about regulation by enforcement. And this is the risk you get with materiality and a principles-based approach. If companies are making these decisions and then later it turns out that it wasn't sufficient disclosure of enforcement actions, whether through the courts or through SEC, is absolutely what we're going to see. And relying on after-the-fact enforcement like that is no way to design a transparent system that works well for investors. It leaves everyone much more likely to not understand which risks are there until it's too late. So the disclosures in my bill are really just designed to get investors consistent, comparable information about large multinational corporations' operations on a country-by-country basis, and do so with such minimal burden on those companies. I ask my colleagues to reject this really unproductive amendment, and I yield back the balance of my time.
Madam Chair.
The gentleman from Texas, Mr. Green, is recognized for 5 minutes to strike the last word.
Thank you very much, Madam Chair. I would ask my friend, Mr. Stahl, a question. Are you available, Mr. Stahl, for a quick question, please?
The time was yield back.
Sorry?
Okay.
All right. Madam Chair, I'm calling on Mr. Stahl to ask him a question.
Available and present.
Oh, thank you. Mr. Stahl, assuming that the company, the corporation, chooses not to disclose the information, what is the remedy available to the investor?
The gentleman yield?
Yes, I yield.
In the situation that the information would be material is I'm assuming is how the question is being asked. And so
No, actually not. The question is asked in this frame. The corporation concludes that the disclosure is not to be granted, the request for disclosure. And the corporation says it's because what you're asking for is not material and that a reasonable investor would not consider this disclosure important. what is the remedy for the investor?
I don't believe there is a remedy in the situation that non-material information is not disclosed.
But let's assume the investor says, yes, it is. That's why I'm asking for it. I believe myself to be a reasonable investor, and I consider this disclosure important. What's the remedy for it?
So if in the, as in all securities law, if a shareholder believes that material information was failed to be disclosed by a publicly traded company, I believe they would have a cause of action against the company. If the
Exactly.
shareholder.
So the investor would have to litigate, is this correct?
That would be one option. The shareholder would, I would also assume, would have the option to bring this forward under current proxy laws to request that this information is specifically disclosed by their respective company. And if the majority of shareholders agreed with the respective shareholder in this hypothetical, I believe then the company could go forward and disclose this, although not required by SEC broad regulation, could be required under company rules.
What we would end up doing is litigating, assuming that this shareholder concludes that this is relevant and material more so than relevant for our purposes now, which means then that the shareholder has to have the ability to take the corporation to court, and the ability would include the funds, which means that the shareholder would have to take on a battery of lawyers. And all this simply does is prevent the shareholder from acquiring the intelligence that this legislation would accord by prolonging it with litigation. This is just another means of avoiding disclosure. And I just don't understand why you have concluded that somehow Justice Marshall indicates that the Congress of the United States cannot define what materiality is, which is what she's doing. She's defining it. And there's nothing wrong, pardon me by saying she, but the Congresswoman is doing this. And the law permits this. So what you're trying to do is maintain a burden on the shareholder to expend funds, take on a battery of lawyers, and probably, if you succeed, it will be after time has lapsed such that the information may not even be material in terms of usage. Madam Chair, I will yield back.
The gentleman yields. Now, the gentleman from Michigan, Mr. Huizinga, is recognized for 5 minutes to strike the last word.
Thank you, Madam Chair. Well, I'm glad to see my friends on the other side, our committee Democrats, embracing the Business Roundtable and the U.S. Chamber of Commerce and rejecting trial lawyers. We've made progress. Except, frankly, you can have the U.S. Chamber and Business Roundtable because I'm not interested in just supporting the 50th or 200 largest companies in this country. I'm actually worried about the entrepreneur and those that are building those businesses. And let's not kid ourselves. This is more about invitations to cocktail parties in New York City and places like that than it is about actually putting disclosures out. I mean, wokeism has hit corporate America. We know that. And, you know, what we're trying to do is flip on its head our entire system of corporate law, which is based on materiality. You know, my friend from Wisconsin, who actually has worked as a corporate attorney dealing with these issues, it recognizes this. And we know that shareholders determine oftentimes what is happening and how their company is functioning. Shareholders can then request disclosures. Now, the other shareholders or a majority of those shareholders have to agree with them, and they can't just have one say, hey, well, I think this is important. Because if that's the case, I'm going to start buying single shares of money of these large companies, and I'm going to start proxying and asking what kind of vehicles the C-suite drives and whether they have vacation homes that they fly to. And, you know, personally, I think if they're using a private jet, even if they own it, I don't know. Maybe that's not a good idea. I mean, we're back to what we've been talking about with previous bills, which is There is no function that my friends on the other side don't see as outside the bounds of the Securities and Exchange Commission, which is just not what it is designed to do. So with that, I'd like to yield to my friend from Wisconsin.
I appreciate the comments from my good friend from the great state of Michigan. I echo your comments regarding Business Roundtable or U.S. Chamber in particular as it relates to the largest companies. The largest companies have huge teams of corporate attorneys that can navigate through securities and law exchange issues. They have the resources to engage in litigation. One of the things that I've been very concerned about for some time is the lack of access to the public markets for some of our smaller companies, in particular, some of our emerging growth companies. I have some legislation that will be coming forward as it relates to emerging growth companies. I hope some of my colleagues will look at and consider engaging with me on. But in particular, as we look at some of the legislation being put forward today, it begins a process of death by 1,000 cuts with the regulatory burden as it relates to these superfluous disclosures. I say superfluous in the sense where they're not material. Where they are material, they should be completely reported. That's true whether or not it's on climate change, whether or not it's pay, whether or not you go down the list. We had one earlier, or maybe it was last Congress, related to HR policies and reporting in the Human Resources Department. If it's material, it should be reported. If it's not, it does not need to be. There's avenues for shareholders to obtain that information. Again, as my colleague from Michigan noted, if a majority of shareholders agree that they would like additional information, regardless of whether or not that information is deemed material, they'd be able to obtain that through a simple shareholder vote. But that democratic process works well if in the event that the company fails to disclose material information, and that's been suggested earlier that there are companies failing to disclose material information, although provided that comment without evidence that that's occurring. Would love to see it if it is something we could look into as a group. I think there'd be group support of that. But just simply putting additional regulatory burdens on businesses, stepping away from the materiality standard, I believe is a step in the wrong direction for the efficiency of our markets, the strength of our capital markets, and the international competitiveness of U.S. capital markets vis-a-vis global competitors, in particular, communist China. And I yield back to my colleague from Michigan.
Thank you. And my friend knows that many large corporations try to use government and government regulations to freeze out their competitors to then take an advantage within the marketplace and then go beg for relief. Just look at the big tech companies. And with that, I yield back.
Is there further debate on the amendment? If not, I recognize myself for 5 minutes. I oppose this amendment. It is an open letter published by investor groups with nearly 2.9 trillion in assets under management. Quote, investors require income and tax information at the country by country level to better understand a company's financial, reputational, and economic risk to make informed investment decisions, end quote. And that quote, investors now more than ever need information to inform them on how their holdings may be affected by changes to the United States tax law, end quote. Many corporations are shifting income generated in the United States to foreign jurisdictions for the purpose of avoiding U.S. tax liability. These types of aggressive tax strategies have left Coca-Cola and Facebook facing a combined $21 billion in potential tax liability, legal fees from court battles over these unpaid taxes, and having their brands associated with tax evasion. As my Republican colleagues have reminded us several times today, the concept of materiality requires disclosure. If a reasonable investor would view the information as important in making an investment decision, quote, reasonable investor, quote, unquote, would clearly need to know that a company they are invested in or considering investing in is invoking a tax strategy that could result in a multi-billion-dollar payment, substantial legal fees, damage to the company's brand, and respect to Facebook shutting down a foreign subsidiary. So yes, it is about corporations who enjoy substantial profits in the United States, paying their fair share, but it is also about informing investors about the substantial risk these firms are taking. So I would urge my members to reject this amendment. Is there further debate on the amendment? If not, I withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye.
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 Those opposed, no. No.
No.
In the opinion of the chair, the noes have it. The noes have it, and the amendment is not agreed to.
Madam Chair, I request a recorded vote.
A recorded vote has been requested. All in favor of a recorded vote, shall raise their hands and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion of or amendment to the bill?
Got an amendment. I got an amendment at the desk.
The gentleman from Texas, Mr. Williams, is recognized. We have an amendment at the desk. We will pause to allow copies of the amendment to be distributed electronically. What happened to the floor vote?
So I'll just, she starts reading all this. Okay. And then I'll just, when first start reading. And then you go to that third line. I ask unanimous consent. Yeah.
Have all members received the amendment? If so, I would like to reserve a point of order on this amendment. The clerk will report the amendment.
Amendment to the amendment in a nature of a substitute to HR 3007.
Without objection, the amendment will be considered as read. The gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Madam Chair. I rise to offer an amendment to the amendment in the nature of a substitute to H.R. 3007. This amendment would demonstrate how increasing the corporate tax rate is detrimental to employees, business investment, and the overall economy. If we were going to force businesses to disclose non-material information, then why would we not show the effects of bad policy, public policy coming from Washington? My amendment would show that taxes that a company would have paid today under the Trump tax cuts that spurred the tightest labor market and strongest economy in decades, and how any proposed increase coming out of Washington would affect their bottom line. We know that changes in the tax code will have a drastic impact on companies' operations. As a business person myself, I've been responsible for making payroll and signing checks that people need to support their families for 50 years. I've dealt with obtaining capital to expand operations and seen firsthand how investing in your business generates economic activity in many different industries within the community. There are so many challenges and unknowns that you deal with while running a business, and anything that decreases the amount of operating capital will make it harder to keep the lights on. Regardless of the size of the business, these principles remain the same. The more money that is taken from a business in taxes, the less the company will be able to hire new employees and invest back into their operations. If this committee is going to require companies to disclose other tax-related information to help investors, then we should at least shine some light on how decisions of politicians here in America are affecting their bottom lines. If the Democrats really want to go down the slippery slope of disclosing non-material information, then let's show investors the effects of bad public policy. I urge all my colleagues to support my amendment, and I yield back the balance of my time.
Is there further debate on the amendment? I now recognize myself for 5 minutes. I oppose this amendment. Republicans have cited the materiality standard and use it as a basis for opposing amendments that are clearly material. Then, in a turn of events, they propose an amendment whose only purpose is to highlight the priorities of my Republican colleagues: tax cuts for the rich. When the United States government should have been focused on growing jobs, the former president pushed forward the largest tax giveaway to public corporations and executives ever. They provided executives and corporations with $2 trillion in tax cuts and giveaways, saddling the U.S. government with a massive deficit that it could have instead sought to close. These tax cuts did not primarily go to workers, but instead they went overwhelmingly to the top 1%. The year after the Trump tax cuts were implemented, public companies spent nearly $1 trillion in stock buybacks rather than investing in their companies, increasing worker wages, or shoring up their bottom line. Additionally, according to the Center on Budget Policies and Priorities, Trump's tax plan gave the top 400 largest income Americans $15 million. Compare that to the fact that workers will only make $2.8 million over their lifetimes. This amendment suggests that a company that may be avoiding paying taxes in the United States can avoid telling shareholders if, heaven forbid, Congress suggests that corporations should pay their fair share in taxes. And so, I think it's very clear. I urge members to reject this amendment, and I yield back the balance of my time. If there's no further debate on the amendment, I withdraw my point of order. The question now occurs on the amendment. All those in favor of the amendment say aye. Those opposed, no.
No.
In the opinion, no. In the opinion of the chair.
Ask for a recorded vote.
The noes have it. A recorded vote has been requested. All in favor of a recorded vote should raise their hand and be counted. There is a sufficient second, and a recorded vote is so ordered. Pursuant to the chair's previous order, the vote on this question is postponed. Is there further discussion or amendment to the bill? If there are no further amendments, without objection, the previous question is ordered on H.R. 3007, and pursuant to Section C5 of Committee Rule 3, further proceedings on the pending amendments are postponed. There being no other matters pending before the committee, the chair wishes to inform members that votes will occur following the floor votes today. We will vote on all postponed matters. And with that, the committee stands in recess. committee's parliamentarian and general counsel. For the past 2 years, he has shepherded this committee through marathon markups, more than 100 hearings, and countless late nights passing and shaping legislation for the benefit of the American public. He expertly guided negotiations around the National Defense Authorization Act, helping ensure the inclusion of reforms to our anti-money laundering laws were included, in addition to several other measures from members on both sides of the aisle. Now, some of you may know that we asked David to come out of retirement to once again serve in the House, and we are immensely grateful for him doing so. So, David, we all wish you the very best in your retirement. And thank you for your service, thank you for your commitment, and thank you for coming out of retirement and coming back to work with us. And I don't know what you're going to do in your retirement, but you may change your mind again.
Madam Chair.
Mr. McHenry?
If the gentleman would yield. I'd like to say thank you to David for his service on the committee. I know he previously was with the Foreign Affairs Committee here in the House, and I want to commend him for having the good judgment to serve on this side of the Capitol rather than that other side of the Capitol, and then served also at the State Department. And so, I think it's important to thank our staff for good service, especially somebody who's willing to come out of retirement to come to this political environment here on Capitol Hill. We really appreciate your service, David. And David, you've been instrumental in keeping this committee honest, even when it's uncomfortable, that the rules are the way they are, but we appreciate the honest exchange. And thank you for your service to our government. That matters a lot. Public service matters. And the examples we have on committee staff on both sides, the tenacity that they bring, the deep knowledge that they bring is so important for us as policymakers. So I'm grateful for your service, David. I'm grateful for the service of our committee staff. So thanks so much for your service, and I hope you enjoy retirement. And so hopefully the votes here won't bring any drama, so you can get to that. So with that, yield back.
Now, before we proceed with the committee's business, I want to review the process we will use for recording votes to ensure that all members can be recorded properly. The clerk will call a member's name twice if a response is not heard the first time. Further, at the end of the roll, the clerk will call the names of any members whose votes were not recorded. Therefore, any members who are unsure if their vote was recorded should refrain from seeking recognition and allow the clerk to continue calling the roll. Members on the platform are reminded that the majority and minority clerks will be verifying that members are both visible and audible in order for their vote to be counted. There is typically a slight delay from the time you unmute and turn on your camera to the time when you can actually be heard and seen by others. So members are encouraged to turn on their cameras in advance and to wait 1 or 2 seconds after they unmute to begin speaking. In some instances, members on the platform may be seen and heard by those on the platform, but not by those in the hearing room. To address this, the majority and minority clerks have earpieces and are logged into the platform to ensure that they can hear and see what is happening on the platform. The committee will now take the votes that were previously postponed. The question now occurs on ordering H.R. 166 as amended to be reported favorably to the House. The clerk will call the roll.
Mrs. Maloney.
Maloney votes yes.
Mrs. Maloney votes aye. Ms. Velázquez.
Velázquez votes aye.
Miss Velázquez votes aye. Mr. Sherman.
Sherman is an aye.
Mr. Sherman votes aye. Mr. Meeks.
Meeks votes aye.
Mr. Meeks votes aye. Mr. Scott. Mr. Scott votes aye. Mr. Green. Mr. Green.
Green votes yea.
Mr. Green votes aye. Mr. Cleaver.
Aye.
Mr. Cleaver votes aye. Mr. Palmer.
Perlmutter votes aye.
Mr. Palmer votes aye. Mr. Himes.
Himes votes aye.
Mr. Himes votes aye. Mr. Foster.
Foster votes aye.
Mr. Foster votes aye. Mrs. Beatty. Mrs. Beatty.
Mrs. Beatty votes aye.
Mrs. Beatty votes aye. Mr. Vargas.
Vote me with the chair. Aye.
Mr. Vargas votes aye. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas.
Gonzalez of Texas votes aye. Gonzalez of Texas votes aye.
Mr. Gonzalez votes aye. Mr. Lawson.
Aye.
Mr. Lawson votes aye. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes aye.
Ms. Axne votes aye. Mr. Casten.
Casten votes with Vargas. Aye.
Mr. Casten votes aye. Ms. Presley.
Presley votes aye.
Ms. Presley votes aye. Mr. Torres.
Torres votes aye.
Mr. Torres votes aye. Mr. Lynch. Mr. Lynch. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Ms. Tlaib. Ms. Tlaib. Ms. Dean.
Dean, aye.
Ms. Dean votes aye. Ms. Ocasio-Cortez.
Ocasio-Cortez, aye.
Ms. Ocasio-Cortez votes aye. Mr. Garcia of Illinois.
Garcia is an aye.
Mr. Garcia votes aye. Ms. Garcia of Texas.
Garcia of Texas votes aye.
Ms. Garcia votes aye. Ms. Williams of Georgia.
Williams of Georgia votes aye.
Ms. Williams votes aye. Mr. Auchincloss.
Auchincloss votes aye.
Mr. Auchincloss votes aye. Mr. McHenry. Mr. McHenry votes no. Mrs. Wagner.
Wagner votes no.
Mrs. Wagner votes no. Mr. Lucas.
Lucas, no.
Mr. Lucas votes no. Mr. Posey.
Posey, no.
Mr. Posey votes no. Mr. Lukenmeyer. Mr. Lukenmeyer votes no. Mr. Huizenga.
Huizenga votes no.
Mr. Huizenga votes no. Mr. Stivers. Mr. Stivers votes no. Mr. Barr.
No.
Mr. Barr votes no. Mr. Williams of Texas. Mr. Williams of Texas votes no. Mr. Hill. Mr. Hill votes no. Mr. Emmer. Mr. Emmer. Mr. Zeldin.
Zeldin votes no.
Mr. Zeldin votes no. Mr. Loudermilk.
Loudermilk votes no.
Mr. Loudermilk votes no. Mr. Mooney.
Mr. Mooney votes no.
Mr. Mooney votes no. Mr. Davidson. Davidson. Mr. Budd.
Bud votes no.
Mr. Budd votes no. Mr. Kustoff.
No.
Mr. Kustoff votes no. Mr. Hollingsworth.
Hollingsworth votes no.
No, I just was
Mr.
distracted for a
Hollingsworth
bit.
votes no. Mr. Gonzalez of Ohio. Mr. Gonzalez votes no. Mr. Rose.
I had the volume down too low.
Rose votes no.
Mr. Rose.
Mr. Rose votes no.
Mr. Rose votes no. Mr. Stile.
Style votes no.
Mr. Stile votes no. Mr. Gooden.
Gooden votes no.
Mr. Gooden votes no. Mr. Timmons.
Timmons votes no.
Mr. Timmons votes no. Mr. Taylor. Mr. Taylor votes no. Madam Chair.
How,
The chair votes aye. I will
How
now
is
be
to
going
leave it-
over the members.
thank you.
I will be going over the members that I missed in the original order, starting with Mr. San Nicolas. Mr. Lynch. Ms. Talib.
Talib votes yes, and thank you for going back over the names.
Ms. Talib votes aye. Mr. Emmer.
Aye. Franklin, how did the chair vote?
Mr. Emmer.
I'm here, Franklin.
You're a no, Tom.
I'm a no, but I want to know how the chair voted. That's fine. Emerson, no.
Mr. Emmer votes no. Mr. Davidson.
Davidson votes no. No.
Mr. Davidson votes no. And that concludes the roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 28 ayes and 24 noes.
Majority having voted in favor, H.R. 166, as amended, is reported favorably to the House. The chair will now call for the votes that were postponed on H.R. 3009. The question now occurs on the Loudermilk Amendment. The clerk will call the roll.
Mrs. Maloney.
Mrs. Maloney votes aye. No. Excuse me, no. Mrs. Maloney votes no. Mrs. Maloney
Mrs.
votes
Maloney. Mrs. Maloney votes no. Ms. Velázquez.
Velázquez votes no.
Ms. Velázquez votes no. Mr. Sherman.
Sherman votes no.
Mr. Sherman votes no. Mr. Meeks.
Meeks votes no.
Mr. Meeks votes no. Mr. Scott. Mr. Scott votes no. Mr. Green.
Green votes nay.
Mr. Green votes no. Mr. Cleaver.
No.
Mr. Cleaver votes no. Mr. Palmer.
Perlmutter votes no.
Mr. Palmer votes no. Mr. Himes.
Himes votes no.
Mr. Himes votes no. Mr. Foster.
Foster votes no.
Mr. Foster votes no. Mrs. Beatty. Mrs. Beatty. Mr. Vargas.
Vargas, no.
Mr. Vargas votes no. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas.
Hold on 1 minute.
Gonzalez votes no.
Mr. Gonzalez votes no. Mr. Lawson.
I vote no.
Mr. Lawson votes no. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes no.
Ms. Axne votes no. Mr. Casten.
Casten votes no.
Mr. Casten votes no. Ms. Presley.
Presley votes no.
Ms. Presley votes no. Mr. Torres.
Torres votes no.
Mr. Torres votes no. Mr. Lynch.
Mr. Lynch votes no.
Mr. Lynch votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Ms. Tlaib.
Sorry about that. Talib votes no.
Ms. Tlaib votes no. Ms. Dean.
Dean, no.
Ms. Dean votes no. Ms. Ocasio-Cortez.
No.
Ms. Ocasio-Cortez votes no. Mr. Garcia of Illinois.
Garcia, no.
Mr. Garcia votes no. Ms. Garcia of Texas.
Garcia of Texas votes no.
Ms. Garcia votes no. Ms. Williams of Georgia.
Williams of Georgia votes no.
Ms. Williams votes no. Mr. Auchincloss.
Auchincloss votes no.
Mr. Auchincloss votes no. Mr. McHenry. Mr. McHenry votes aye. Mrs. Wagner.
Wagner, aye.
Mrs. Wagner votes aye. Mr. Lucas.
Lucas votes yes.
Mr. Lucas votes aye. Mr. Posey.
Yes.
Mr. Posey votes aye. Mr. Lukemeyer. Mr. Lukemeyer votes aye. Mr. Huizenga.
Huizenga votes aye.
Mr. Huizenga votes aye. Mr. Stivers. Mr. Stivers votes aye. Mr. Barr.
Aye.
Mr. Barr votes aye. Mr. Williams of Texas. Mr. Williams votes aye. Mr. Hill.
Aye.
Mr. Hill votes aye. Mr. Emmer.
Yes.
Mr. Emmer votes aye. Mr. Zeldin.
Aye.
The vaccinations do in fact.
Zeldin votes aye.
Mr. Zeldin votes aye. Mr. Loudermilk.
Loudermilk votes aye.
Mr. Loudermilk votes aye. Mr. Mooney.
Mooney votes aye.
Mr. Mooney votes aye. Mr. Davidson.
Davidson, aye.
Mr. Davidson votes aye. Mr. Budd.
Bud votes aye.
Mr. Budd votes aye. Mr. Kustoff.
Aye.
Mr. Kustoff votes aye. Mr. Hollingsworth.
Hollingsworth votes aye.
Mr. Hollingsworth votes aye. Mr. Gonzalez of Ohio. Mr. Gonzalez votes aye. Mr. Rose.
Rose votes yes.
Mr. Rose votes aye. Mr. Stiles.
Yes. Mr. Style votes yes.
Mr. Stiles votes aye. Mr. Gooden.
Gooden votes aye.
Mr. Gooden votes aye. Mr. Timmons.
Timmons votes aye.
Mr. Timmons votes aye. Mr. Taylor. Mr. Taylor votes aye. Madam Chair. The chair votes no. Now we are going to go over to the members that we missed in the original order, starting with Mrs. Beatty.
Mrs. Beatty votes no.
Mrs. Beatty votes no. Mr. San Nicolas? And that concludes the roll call for that vote.
Based on the roll call, It appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 25 ayes and 28 noes.
A majority having voted against the amendment is not agreed to. The question now occurs on adoption of the amendment in the nature of a substitute offered by Ms. Garcia. All those in favor say aye.
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 Those opposed, no.
Aye.
No.
No.
In the opinion of the chair, the ayes have it.
That's
The ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering H.R. 3009 as amended to be reported favorably to the House. All those in favor say aye.
Aye.
Your PIN followed pound or hash. If you do not
Those
know your
opposed,
PIN,
no.
please enter pound or
In the opinion of the chair,
No.
the ayes have it.
Ask
The
for a
ayes
recorded vote.
have it, and H.R. 3009 as amended is reported favorably to the House.
I ask for a recorded vote.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted.
Nope.
A sufficient number having raised their hands, a recorded vote is so ordered. The clerk will call the roll.
Mrs. Maloney.
Mrs. Maloney votes aye.
Mrs. Maloney votes aye.
Yes,
Ms. Velázquez.
Velázquez votes aye.
My computer.
Ms. Velázquez.
Votes no. Aye.
Ms. Velázquez votes aye. Mr. Sherman.
Sherman votes aye.
Mr. Sherman votes aye.
You
Mr.
didn't hear
Meeks.
me.
Mr. Meeks votes aye.
Mr. Meeks votes aye. Mr. Scott. Mr. Scott votes aye. Mr. Green.
Green votes yay.
Mr. Green votes aye. Mr. Cleaver.
Aye.
Mr. Cleaver votes aye. Mr. Palmer.
Perlmutter votes aye.
Mr. Palmer votes aye. Mr. Himes.
Himes votes aye.
Mr. Himes votes aye. Mr. Foster.
Foster votes aye.
Mr. Foster votes aye. Mrs. Beatty.
Beatty votes aye.
Mrs. Beatty votes aye. Mr. Vargas.
Vargas, aye.
Mr. Vargas votes aye. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas. Mr. Gonzalez of Texas. Mr. Lawson.
Aye.
Mr. Lawson votes aye. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes aye.
Ms. Axne votes aye. Mr. Casten.
Casten votes aye.
Mr. Casten votes aye. Ms. Presley.
Presley votes aye.
Ms. Presley votes aye. Mr. Torres.
Mr. Torres votes aye.
Mr. Torres votes aye. Mr. Lynch.
Mr. Lynch votes aye.
Mr. Lynch votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Ms. Talib.
Okay. Talib votes yes.
Ms. Talib votes aye. Ms. Dean.
Dean, yes.
Ms. Dean votes aye. Ms. Ocasio-Cortez.
Aye.
Ms. Ocasio-Cortez votes aye. Mr. Garcia of Illinois.
Garcia is an aye.
Mr. Garcia votes aye. Ms. Garcia of Texas.
Garcia of Texas votes yes.
Ms. Garcia votes aye. Ms. Williams of Georgia.
Williams of Georgia votes aye.
Ms. Williams votes aye. Mr. Auchincloss. Mr. Auchincloss. Mr. McHenry. Mr. McHenry votes no. Mrs. Wagner.
Wagner, no.
Mrs. Wagner votes no. Mr. Lucas.
Lucas votes no.
Mr. Lucas votes no. Mr. Posey.
No.
Mr. Posey votes no. Mr. Lukemeyer. Mr. Lukemeyer votes no. Mr. Huizinga.
Huizinga votes no.
Mr. Huizinga votes no. Mr. Stivers. Mr. Stivers votes no. Mr. Barr.
No.
Mr. Barr votes no. Mr. Williams of Texas. Mr. Williams votes no. Mr. Hill. Mr. Hill votes no. Mr. Emmer.
No.
Mr. Emmer votes no. Mr. Zeldin.
Zeldin votes no.
Mr. Zeldin votes no. Mr. Loudermilk.
Loudermilk votes no.
Mr. Loudermilk votes no. Mr. Mooney.
Mooney votes no.
Mr. Mooney votes no. Mr. Davidson.
Davidson votes no.
Mr. Davidson votes no. Mr. Budd.
Bud votes no.
Mr. Budd votes no. Mr. Kustoff.
No.
Mr. Kustoff votes no. Mr. Hollingsworth.
Hollingsworth votes no.
Mr. Hollingsworth votes no. Mr. Gonzalez of Ohio. Mr. Gonzalez votes no. Mr. Rose.
Rose votes no.
Mr. Rose votes no. Mr. Stile.
Mr. Stile votes no.
Mr. Stile votes no. Mr. Gooden.
Gooden votes no.
Mr. Gooden votes no. Mr. Timmons.
Timmons votes no.
Mr. Timmons votes no. Mr. Taylor. Mr. Taylor votes no. Madam Chairwoman. Chair votes aye. I will now go over the members that were missed in the original order, starting with Mr. Gonzalez of Texas.
Gonzalez of Texas votes aye.
Mr. Gonzalez votes aye. Mr. San Nicolas. And that will conclude. Thank you. Mr. Auchincloss.
Auchincloss votes aye.
Mr. Auchincloss votes aye. And that will conclude the roll call for this vote, Madam Chair.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 29 ayes and 24 noes.
A majority having voted in favor, H.R. 3009 as amended is reported favorably to the House. The chair will now call for the votes that were postponed on H.R. 2570. Without objection, the chair will consider the Hill Amendment and the Barr Amendment en bloc. The question now occurs on the Hill and Barr Amendments en bloc. The clerk will call the roll.
Mrs. Maloney.
Mrs. Maloney votes no.
Mrs. Maloney votes no. Ms. Velázquez.
Velázquez votes no.
Ms. Velázquez votes no. Mr. Sherman.
Sherman votes no.
Mr. Sherman votes no. Mr. Meeks.
Meeks votes no.
Mr. Meeks votes no. Mr. Scott. Mr. Scott votes no. Mr. Green.
Green votes nay.
Mr. Green votes no. Mr. Cleaver. Mr. Cleaver.
No.
Mr. Cleaver votes no. Mr. Palmer.
Perlmutter votes no.
Mr. Palmer votes no. Mr. Himes.
Himes votes no.
Mr. Himes votes no. Mr. Foster.
Foster votes no.
Mr. Foster votes no. Mrs. Beatty.
Mrs. Beatty votes no.
Mrs. Beatty votes no. Mr. Vargas.
Vargas, no.
Mr. Vargas votes no. Mr. Gottheimer.
Gottheimer votes no.
Mr. Gottheimer votes no. Mr. Gonzalez of Texas. Mr. Gonzalez of Texas. Mr. Lawson.
No.
Mr. Lawson votes no. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne. Ms. Axne.
Axne votes no.
Ms. Axne votes no. Mr. Casten.
Casten votes no.
Mr. Casten votes no. Ms. Presley.
Presley votes no.
Ms. Presley votes no. Mr. Torres.
Torres votes no.
Mr. Torres votes no. Mr. Lynch.
Mr. Lynch votes no.
Mr. Lynch votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Ms. Tlaib.
Talib votes no.
That's for sure.
Ms. Tlaib votes no. Ms. Dean.
Dean, no.
Ms. Dean votes no. Ms. Ocasio-Cortez.
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Mr. Garcia of Illinois.
Garcia, no.
Mr. Garcia votes no. Ms. Garcia of Texas.
Garcia votes no.
Ms. Garcia votes no. Ms. Williams of Georgia.
Williams of Georgia votes no.
Ms. Williams votes no. Mr. Auchincloss. Mr. Auchincloss. Mr. McHenry. Mr. McHenry votes aye. Mrs. Wagner. Mrs. Wagner.
Wagner votes yes.
Mrs. Wagner votes aye. Mr. Lucas.
Lucas votes yes.
Mr. Lucas votes aye. Mr. Posey.
Yes.
Mr. Posey votes aye. Mr. Lukemeyer. Mr. Lukemeyer votes aye. Mr. Huizinga.
Huizinga, yes.
Mr. Huizinga votes aye. Mr. Stivers. Mr. Stivers votes aye. Mr. Barr.
Aye.
Mr. Barr votes aye. Mr. Williams of Texas. Mr. Williams votes aye. Mr. Hill. Mr. Hill votes aye. Mr. Emmer.
Emmer, yes.
Mr. Emmer votes aye. Mr. Zeldin.
Zeldin votes aye.
Mr. Zeldin votes aye. Mr. Loudermilk.
Loudermilk votes aye.
Mr. Loudermilk votes aye. Mr. Mooney.
Mooney votes aye.
Mr. Mooney votes aye. Mr. Davidson.
Davidson votes aye.
Mr. Davidson votes aye. Mr. Budd.
Bud votes aye.
Mr. Budd votes aye. Mr. Kustoff.
Aye.
Mr. Kustoff votes aye. Mr. Hollingsworth.
Hollingsworth votes aye.
Mr. Hollingsworth votes aye. Mr. Gonzalez of Ohio. Mr. Gonzalez votes aye. Mr. Rose.
Rose votes yes.
Ms. Rose votes aye. Mr. Stile.
Stile votes aye.
Mr. Stile votes aye. Mr. Gooden.
Gooden votes aye.
Mr. Gooden votes aye. Mr. Timmons.
Timmons votes aye.
Mr. Timmons votes aye. Mr. Taylor. Mr. Taylor votes aye. Madam Chair. The chair votes no. I will now be going over the members I missed in the original order, starting with Mr. Gonzalez of Texas. Mr. San Nicolas. Mr. Auchincloss. And that will conclude the roll call for that vote, Madam Chair.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 24 ayes and 27 noes.
A majority having voted against the unblock amendments, the unblock amendments are not agreed to. The question now appears on adoption of the amendment in the nature of a substitute offered by Mr. Casten. All of those in favor say aye.
Aye.
Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering HR 2570 as amended to be reported favorably to the House. All those in favor say aye.
Aye. Aye.
Aye.
Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and HR
Madam Chair,
2570
ask
as
for-
amended is reported favorably.
Ask for a recorded vote.
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered. The clerk will call the roll.
Mrs. Maloney.
Maloney votes aye.
Mrs. Maloney votes aye. Ms. Velázquez.
Velázquez votes aye.
Ms. Velázquez votes aye. Mr. Sherman.
Sherman votes aye.
Mr. Sherman votes aye. Mr. Meeks.
Meeks votes aye.
Mr. Meeks votes aye. Mr. Scott. Mr. Scott votes aye. Mr. Green.
Green votes yea.
Mr. Green votes aye. Mr. Cleaver.
Aye.
Mr. Cleaver votes aye. Mr. Palmer.
Aye.
Mr. Palmer votes aye. Mr. Himes.
Himes votes aye.
Mr. Himes votes aye. Mr. Foster.
Foster votes aye.
Mr. Foster votes aye. Mrs. Beatty.
Mrs. Beatty votes aye.
Mrs. Beatty votes aye. Mr. Vargas.
Vargas, aye.
Mr. Vargas votes aye. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas. Mr. Gonzalez of Texas. Mr. Lawson.
Aye.
Mr. Lawson votes aye. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne. Ms. Axne.
I'm trying to unmute here.
Mr. Casten.
Axne votes aye. I finally got unmuted. Thank you.
Ms. Axne votes aye. Mr. Casten.
Casten votes aye with no unmuting troubles.
Mr. Casten votes aye. Ms. Presley.
Presley votes aye.
Ms. Presley votes aye. Mr. Torres.
Torres votes aye.
Mr. Torres votes aye. Mr. Lynch.
Mr. Lynch votes aye.
Mr. Lynch votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Ms. Tlaib.
Tlaib votes yes.
Ms. Tlaib votes aye. Ms. Dean.
Dean, aye.
Ms. Dean votes aye. Ms. Ocasio-Cortez.
Aye.
Ms. Ocasio-Cortez votes aye. Mr. Garcia of Illinois.
Aye.
Mr. Garcia votes aye. Ms. Garcia of Texas.
Garcia of Texas votes aye.
Ms. Garcia votes aye. Mr. Williams of Georgia.
Williams of Georgia votes aye.
Mr. Williams votes aye. Mr. Auchincloss. Mr. Auchincloss. Mr. McHenry.
No.
Mr. McHenry votes no. Mrs. Wagner.
Wagner votes no.
Mrs. Wagner votes no. Mr. Lucas.
Lucas votes no.
Mr. Lucas votes no. Mr. Posey.
No.
Mr. Posey votes no. Mr. Lukemeyer. Mr. Lukemeyer votes no. Mr. Huizinga.
No.
Mr. Huizinga votes no. Mr. Stivers. Mr. Stivers votes no. Mr. Barr.
No.
Mr. Barr votes no. Mr. Williams of Texas. Mr. Williams votes no. Mr. Hill. Mr. Hill votes no. Mr. Emmer.
Emmer, no.
Mr. Emmer votes no. Mr. Zeldin.
Zeldin votes no.
Mr. Zeldin votes no. Mr. Loudermilk.
Loudermilk votes no.
Mr. Loudermilk votes no. Mr. Mooney.
Mooney votes no.
Mr. Mooney votes no. Mr. Davidson.
Davidson votes no.
Mr. Davidson votes no. Mr. Budd.
Bud votes no.
Mr. Budd votes no. Mr. Kustoff.
No.
Mr. Kustoff votes no. Mr. Hollingsworth.
Hollingsworth votes no.
Mr. Hollingsworth votes no. Mr. Gonzalez of Ohio. Mr. Gonzalez votes no. Mr. Rose.
Rose votes no.
Mr. Rose votes no. Mr. Stile.
Dial votes no.
Mr. Stile votes no. Mr. Gooden.
Gooden votes no.
Mr. Gooden votes no. Mr. Timmons.
Timmons votes no.
Mr. Timmons votes no. Mr. Taylor. Mr. Taylor votes no. Madam Chairwoman.
Aye.
The chair votes aye. We will now go over the members that were missed in the original order, starting with Mr. Gonzalez of Texas. Mr. San Nicolas. Mr. Auchincloss.
Auchincloss votes aye.
Mr. Auchincloss votes aye. And that will conclude the roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 28 ayes and 24 noes.
A majority having voted in favor, H.R. 2570 as amended is reported favorably to the House. The chair will now call for the votes that were postponed on H.R. 1188. Without objection, the committee will consider the style amendment and the Huizenga Amendment unblock. The question now occurs on the Style and Huizenga Amendments unblock. The clerk will call the roll.
Mrs. Maloney.
Carolyn Maloney votes no.
Mrs. Maloney votes no. Ms. Velázquez.
Velázquez is no.
Ms. Velázquez votes no. Mr. Sherman.
Sherman votes no.
Mr. Sherman votes no. Mr. Meeks.
Meeks votes no.
Mr. Meeks votes no. Mr. Scott. Mr. Scott votes no. Mr. Green.
Green votes nay.
Mr. Green votes no. Mr. Cleaver.
No.
Mr. Cleaver votes no. Mr. Palmer.
It pains me to vote against both of these guys at the same time, but no.
Mr. Palmer votes no. Mr. Himes.
Himes votes no.
Mr. Himes votes no. Mr. Foster.
Foster, no.
Mr. Foster votes no. Mrs. Beatty.
Mrs. Beatty votes no.
Mrs. Beatty votes no. Mr. Vargas.
Vargas, no.
Mr. Vargas votes no. Mr. Gottheimer. Mr. Gottheimer. Mr. Gonzalez of Texas.
Gonzalez votes no.
Mr. Gonzalez votes no. Mr. Lawson.
No.
Mr. Lawson votes no. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes no.
Ms. Axne votes no. Mr. Casten.
Casten votes no.
Mr. Casten votes no. Ms. Presley.
Presley votes no.
Ms. Presley votes no. Mr. Torres.
Torres votes no.
Mr. Torres votes no. Mr. Lynch.
Mr. Lynch votes no.
Mr. Lynch votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Ms. Tlaib. Ms. Tlaib. Ms. Dean.
Dean, yes.
Ms.
Dean,
Dean.
yes.
Ms. Dean votes aye. Ms. Ocasio-Cortez.
I got that wrong. Dean is a no.
Ms. Dean off aye on no. Ms. Ocasio-Cortez. Ms. Ocasio-Cortez. Mr. Garcia of Illinois.
Garcia is no.
Mr. Garcia votes no. Ms. Garcia of Texas.
Garcia of Texas, no.
Ms. Garcia votes no. Ms. Williams of Georgia.
Williams of Georgia votes no.
Ms. Williams votes no. Mr. Auchincloss.
Auchincloss votes no.
Mr. Auchincloss votes no. Mr. McHenry. Mr. McHenry votes aye. Mrs. Wagner.
Wagner votes aye.
Mrs. Wagner votes aye. Mr. Lucas.
Lucas votes yes.
So it's like three of the girls and
Mr. Lucas votes aye. Mr. Posey.
Yes.
Mr. Posey votes aye. Mr. Lukemeyer. Mr. Lukemeyer votes aye. Mr. Huizenga.
Huizenga votes aye.
Mr. Huizenga votes aye. Mr. Stivers.
Madam Chair, point of personal privilege, I'd like to say goodbye to everybody. This is my last vote. I won't be voting on the last four because I've got a party I'm going to say goodbye to the rest of my friends. But goodbye, Madam Chair, and what am I on this? A yes?
Wow.
Yes, I'm a yes.
Thank you.
we will miss you, Steve.
I thought you was gonna give us a no on to last.
Hey, Steve.
Thank you very much. Mr.
Bye,
Adams.
Steve.
I miss you.
We love you, Steve.
See you, Stevie.
Miss you, Stivers.
Mr. Stivers.
Mr. Stivers.
Winner.
Yeah, that's right.
I'll say two things about Steve, if I may, Madam Chair, in the middle of this vote. One is I would have a more elaborate thank you at the end of votes, but since he left early, you guys can just read about my tweet. Second, I would say to my Democrat friends, true to being Steve Stivers, he threw a bone to the Democrats on the last 4 votes, so it's pretty bipartisan of him. I'm trying to be lighthearted about it. Anyway, let's move on to votes.
Mr. Stivers votes aye. Mr. Barr.
Aye.
Mr. Barr votes aye.
Barr votes aye.
Mr. Williams of Texas. Mr. Williams votes aye. Mr. Hill. Mr. Hill votes aye. Mr. Emmer.
Emmer, yes.
Mr. Emmer votes aye. Mr. Zeldin.
Zeldin votes aye.
Mr. Zeldin votes aye. Mr. Loudermilk.
Mr. Loudermilk votes aye.
Mr. Loudermilk votes aye. Mr. Mooney.
Mooney votes aye.
Mr. Mooney votes aye. Mr. Davidson.
Davidson votes aye.
Mr. Davidson votes aye. Mr. Budd.
Budd votes aye.
Mr. Budd votes aye. Mr. Kustoff.
Aye.
Mr. Kustoff votes aye. Mr. Hollingsworth.
Hollingsworth votes aye.
Mr. Hollingsworth votes aye. Mr. Gonzalez of Ohio. Mr. Gonzalez votes aye. Mr. Rose.
Rose votes yes.
Mr. Rose votes aye. Mr. Stile.
Stile votes aye.
Mr. Stile votes aye. Mr. Gooden. Mr. Gooden.
Gooden votes aye. Sorry.
Mr. Gooden votes aye. Mr. Timmons.
Timmons votes aye.
Mr. Timmons votes aye. Mr. Taylor. Mr. Taylor votes aye. Madam Chairwoman.
No.
The chair votes no. I will now go over the members that we missed in the original order, starting with Mr. Gottheimer.
Gottheimer votes no.
Mr. Gottheimer votes no. Mr. San Nicolas. Ms. Tlaib.
Tlaib votes no.
Ms. Tlaib votes no. Ms. Ocasio-Cortez.
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. And that will conclude that roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 24 ayes and 29 noes.
A majority having voted against the unblock amendment, the unblock amendments are not agreed to. The question now occurs on adoption of the amendment in the nature of a substitute offered by Ms. Velázquez. All of those in favor say aye.
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 Those no.
Aye.
Aye.
In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering H.R. 1188 as amended to be reported favorably to the House. All those in favor say aye.
Aye.
Those opposed, no.
No.
In the opinion of the chair, the ayes have it.
Ask for a
The
record.
ayes have it, and H.R. 1188 as amended is reported favorably to the House.
Ask
A recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered. The clerk will call the roll.
Mrs. Maloney.
Maloney votes aye.
Mrs. Maloney votes aye. Ms. Velázquez.
Velázquez votes aye.
Ms. Velázquez votes aye. Mr. Sherman.
Chairman votes aye.
Mr. Sherman votes aye. Mr. Meeks.
Meeks votes aye.
Mr. Meeks votes aye. Mr. Scott. Mr. Scott votes aye. Mr. Green.
Green votes yay.
Mr. Green votes aye. Mr. Cleaver.
Aye.
Mr. Cleaver votes aye. Mr. Palmer.
Perlmutter votes aye.
Mr. Palmer votes aye. Mr. Himes.
Himes votes aye.
Mr. Himes votes aye. Mr. Foster.
Foster, aye.
Mr. Foster votes aye. Mrs. Beatty.
Mrs. Beatty votes aye.
Mrs. Beatty votes aye. Mr. Vargas.
Vargas, aye.
Mr. Vargas votes aye. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas.
Gonzalez of Texas votes aye.
Mr. Gonzalez votes aye. Mr. Lawson.
Aye.
Mr. Lawson votes aye. Mr. San Nicolas. Mr. San Nicolas. Ms.
Axne votes aye.
Ms. Axne votes aye. Mr. Casten.
Casten votes aye.
Mr. Casten votes aye. Ms. Presley.
Presley votes aye.
Ms. Presley votes aye. Mr. Torres.
Torres votes aye. Torres votes aye.
Mr. Torres votes aye. Mr. Lynch.
Mr. Lynch votes aye.
Mr. Lynch votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Ms. Tlaib.
Tlaib votes yes.
Ms. Tlaib votes aye. Ms. Dean.
Dean, yes.
Ms. Dean votes aye. Ms. Ocasio-Cortez. Ms. Ocasio-Cortez. Mr. Garcia of Illinois.
Garcia, Illinois is a yes.
Mr. Garcia votes aye. Ms. Garcia of Texas.
Garcia of Texas, yes.
Ms. Garcia votes aye. Ms. Williams of Georgia.
Williams of Georgia votes aye.
Ms. Williams votes aye. Mr. Auchincloss.
Auchincloss votes aye.
Mr. Auchincloss votes aye. Mr. McHenry.
No.
Mr. McHenry votes no. Mrs. Wagner.
Wagner, no.
Mrs. Wagner votes no. Mr. Lucas.
Lucas, no.
Mr. Lucas votes no. Mr. Posey.
Nay.
Mr. Posey votes no. Mr. Lukemeyer. No. Mr. Lukemeyer votes no. Mr. Huizinga.
Huizinga, no.
Mr. Huizinga votes no. Mr. Stivers. Mr. Stivers. Mr. Barr.
No.
Mr. Barr votes no. Mr. Williams of Texas. Mr. Williams votes no. Mr. Hill. Mr. Hill votes no. Mr. Emmer.
Emmer, no.
Mr. Emmer votes no. Mr. Zeldin.
Zeldin votes no.
Mr. Zeldin votes no. Mr. Loudermilk.
Loudermilk votes no.
Mr. Loudermilk votes no. Mr. Mooney. Mr. Mooney. Mr. Davidson.
Nope.
Mr. Davidson votes no. Mr. Budd.
Mooney.
Mr. Budd.
No. Bud votes no.
Mr. Budd votes no. Mr. Kustoff.
No.
Mr. Kustoff votes no. Mr. Hollingsworth.
Hollingsworth votes no.
Hollingsworth votes no. Mr. Gonzalez of Ohio. Mr. Gonzalez votes no. Mr. Rose.
Rose votes no.
Mr. Rose votes no. Mr. Stile.
Stile votes no.
Mr. Stile votes no. Mr. Gooden.
Gooden votes no.
Mr. Gooden votes no. Mr. Timmons.
Timmons votes no.
Mr. Timmons votes no. Mr. Taylor. Mr. Taylor votes no. Madam Chair,
Yes.
the chair votes aye. I will now go over the members that were missed in the original order, starting with Mr. San Nicolas. Ms. Ocasio-Cortez.
Ocasio-Cortez votes aye.
Ms. Ocasio-Cortez votes aye. Mr. Stivers. Mr. Mooney.
Mooney votes no.
Mr. Mooney votes no. And that concludes that roll call for that vote.
Based on the roll call, it appears all members who are present are voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 29 ayes and 23 noes.
A majority having voted in favor, H.R. 1188 as amended is reported favorably to the House. The chair will now call for the votes that were postponed on H.R. 3007. The question now occurs on the style amendment. The clerk will call the roll.
Mrs. Maloney.
No. Maloney votes no.
Mrs. Maloney votes no. Ms. Velázquez.
Velázquez votes no.
Ms. Velázquez votes no. Mr. Sherman.
Sherman votes no.
Mr. Sherman votes no. Mr. Meeks.
Meeks votes no.
Mr. Meeks votes no. Mr. Scott.
Mr. Scott votes no.
Mr. Scott votes no. Mr. Green.
Green votes nay.
Mr. Green votes no. Mr. Cleaver.
No.
Mr. Cleaver votes no. Mr. Perlmutter.
Perlmutter votes no.
Mr. Perlmutter votes no. Mr. Himes.
Himes votes no.
Mr. Himes votes no. Mr. Foster.
Foster no.
Mr. Foster votes no. Mrs. Beatty. Mrs. Beatty. Mr. Vargas.
Vargas no.
Mr. Vargas votes no. Mr. Gottheimer.
Gottheimer votes no.
Mr. Gottheimer votes no. Mr. Gonzalez of Texas.
Gonzalez of Texas votes no.
Mr. Gonzalez votes no. Mr. Lawson.
No.
Mr. Lawson votes no. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes no.
Ms. Axne votes no. Mr. Casten.
Casten votes no.
Mr. Casten votes no. Ms. Presley.
Presley votes no.
Ms. Presley votes no. Mr. Torres.
Torres votes no.
Mr. Torres votes no. Mr. Lynch.
Mr. Lynch votes no.
Mr. Lynch votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Ms. Tlaib.
Lee votes no.
Ms. Tlaib votes no. Ms. Dean.
Dean votes no.
Ms. Dean votes no. Ms. Ocasio-Cortez.
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Mr. Garcia of Illinois.
Garcia votes no.
Mr. Garcia votes no. Ms. Garcia of Texas.
Garcia of Texas votes no.
Ms. Garcia votes no. Mr. Williams of Ms. Williams of Georgia.
Williams of Georgia votes no.
Ms. Williams votes no. Mr. Auchincloss.
Auchincloss votes no.
Mr. Auchincloss votes no. Mr. McHenry.
Aye.
Mr. McHenry votes aye. Mrs. Wagner.
Wagner votes aye.
Mrs. Wagner votes aye. Mr. Lucas.
Lucas votes aye.
Mr. Lucas votes aye. Mr. Posey.
Aye.
Mr. Posey votes aye. Mr. Lukemeyer. Mr. Lukemeyer votes aye. Mr. Huizinga.
Huizinga, aye.
Mr. Huizinga votes aye. Mr. Stivers. Mr. Stivers. Mr. Barr.
Barr votes aye.
Mr. Barr votes aye. Mr. Williams of Texas. Mr. Williams votes aye. Mr. Hill. Mr. Hill votes aye. Mr. Emmer.
Emmer, yes.
Mr. Emmer votes aye. Mr. Zeldin.
Zeldin votes aye.
Mr. Zeldin votes aye. Mr. Loudermilk.
Loudermilk votes aye.
Mr. Loudermilk votes aye. Mr. Mooney. Mr. Mooney. Mr. Davidson.
Aye.
Mr. Davidson votes aye. Mr. Budd.
Bud votes aye.
Mr. Budd votes aye. Mr. Kustoff.
Aye.
Mr. Kustoff votes aye. Mr. Hollingsworth.
Hollingsworth votes aye.
Mr. Hollingsworth votes aye. Mr. Gonzalez of Ohio.
Gonzalez votes aye.
Mr. Gonzalez votes aye. Mr. Rose.
Rose votes yes.
Mr. Rose votes aye. Mr. Stile.
Style votes aye.
Mr. Stile votes aye. Mr. Gooden.
Gooden votes aye.
Mr. Gooden votes aye. Mr. Timmons.
Timmons votes aye.
Mr. Timmons votes aye. Mr. Taylor. Mr. Taylor votes aye. Madam Chair.
No.
Chair votes no. I will now go over the members who were missed in a previous order, starting with Mrs. Beatty.
Mrs. Beatty votes no.
Mrs. Beatty votes no. Mr. San Nicolas. Mr. Stivers. Mr. Mooney.
Mooney votes no.
Mr. Mooney votes no.
Are you sure? Oh, wait, hold on, change that to aye. I'm sorry. Mooney votes aye.
Mr. Mooney off no, on aye.
Thank you.
And that will conclude the roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 23 ayes and 29 noes.
A majority having voted against the amendment is not agreed to. The question now occurs on the Williams amendment. The clerk will call the roll.
Mrs. Maloney.
Mrs. Maloney votes no.
Mrs. Maloney votes no. Ms. Velázquez.
Velázquez votes no.
Ms. Velázquez votes no. Mr. Sherman.
Sherman votes no.
Mr. Sherman votes no. Mr. Meeks.
Meeks votes no.
Mr. Meeks votes no. Mr. Scott.
Scott votes no.
Mr. Scott votes no. Mr. Green.
Green votes nay.
Mr. Green votes no. Mr. Cleaver.
No.
Mr. Cleaver votes no. Mr. Perlmutter.
Perlmutter votes no.
Mr. Perlmutter votes no. Mr. Himes.
Hines votes no.
Mr. Himes votes no. Mr. Foster.
Foster, no.
Mr. Foster votes no. Mrs. Beatty.
Mrs. Beatty votes no.
Mrs. Beatty votes no. Mr. Vargas.
Vargas, no.
Mr. Vargas votes no. Mr. Gottheimer.
Gottheimer votes no.
Mr. Gottheimer votes no. Mr. Gonzalez of Texas.
Gonzalez of Texas votes no.
Mr. Gonzalez votes no. Mr. Lawson.
No.
Mr. Lawson votes no. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes no.
Ms. Axne votes no. Mr. Casten.
Casten votes no.
Mr. Casten votes no. Ms. Presley.
Presley votes no.
Ms. Presley votes no. Mr. Torres.
Well, maybe I better. It's 45 minutes. So maybe I better stay here.
Mr. Torres.
Monitor or recording. If you have any questions
Mr. Lynch.
regarding the bill, the back.
Mr. Lynch votes no.
Mr. Lynch votes no. Ms. Adams.
Adams votes no.
Ms. Adams votes no. Ms. Tlaib.
Tlaib votes no.
Ms. Tlaib votes no. Ms. Dean.
Dean, no.
Ms. Dean votes no. Ms. Ocasio-Cortez.
Ocasio-Cortez votes no.
Ms. Ocasio-Cortez votes no. Mr. Garcia of Illinois.
Garcia is a no.
Mr. Garcia votes no. Ms. Garcia of Texas.
Garcia of Texas is no.
Ms. Garcia votes no. Ms. Williams of Georgia.
Williams of Georgia votes no.
Ms. Williams votes no. Mr. Auchincloss.
Auchincloss votes no.
Mr. Auchincloss votes no. Mr. McHenry. Mr. McHenry votes aye. Mrs. Wagner.
Wagner votes aye.
Mrs. Wagner votes aye. Mr. Lucas.
Lucas votes aye.
Mr. Lucas votes aye. Mr. Posey.
Aye.
Mr. Posey votes aye. Mr. Lukemeyer. Mr. Lukemeyer votes aye. Mr. Huizinga.
Huizinga, aye.
Mr. Huizinga votes aye. Mr. Stivers.
Jeannie Mancini and Anne Marie.
Mr. Stivers. Mr. Barr.
Aye.
Mr. Barr votes aye. Mr. Williams of Texas. Mr. Williams votes aye. Mr. Hill. Mr. Hill votes aye. Mr. Emmer.
Emmer, yes.
Mr. Emmer votes aye. Mr. Zeldin.
Zeldin votes aye.
Mr. Zeldin votes aye. Mr. Loudermilk.
Loudermilk votes aye.
Mr. Loudermilk votes aye. Mr. Mooney.
Mooney votes aye.
Mr. Mooney votes aye. Mr. Davidson.
Davidson votes aye.
Mr. Davidson votes aye. Mr. Budd.
Bud votes aye.
Mr. Budd votes aye.
Will the clerk suspend? Please stay muted until you are responding to the roll call. The interference is creating some problems for members. Thank you. Mr. Clerk, you may proceed.
Mr. Kustoff.
Aye.
Mr. Kustoff votes aye. Mr. Hollingsworth.
Hollingsworth votes no.
Mr. Hollingsworth votes no. Mr. Gonzalez of Ohio.
Aye.
Mr. Gonzalez votes aye. Mr. Rose.
Rose votes yes.
Mr. Rose votes aye. Mr. Stile.
Style votes aye.
Mr. Stile votes aye. Mr. Gooden. Mr. Gooden. Mr. Timmons.
Timmons votes aye.
Mr. Timmons votes aye. Mr. Taylor. Mr. Taylor votes aye. Madam Chair. Chair votes no. I will now go over the members that were missed in the previous order. Mr. San Nicolas. Mr. Torres. Mr. Stivers. Mr. Gooden.
Gooden votes aye.
Mr. Gooden votes aye. And that will conclude the roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 22 ayes and 29 noes.
A majority having voted against the amendment is not agreed to. The question now occurs on adoption of the amendment in the nature of a substitute offered by Ms. Axne. All those in favor say aye.
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 Those opposed, no.
Aye.
In the opinion of the chair, the ayes have it. The ayes have it, and the amendment in the nature of a substitute is agreed to. The question now occurs on ordering H.R. 3007 as amended to be reported favorably to the House. All those in favor say aye.
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 Those opposed, no. In the
No.
opinion of the chair, the ayes have it. The ayes have it,
Ask for a court
and
vote.
H.R. 3007 is reported favorable to the House.
Ask for a
A
court.
recorded vote has been requested. All those in favor of a recorded vote shall raise their hand and be counted. A sufficient number having raised their hands, a recorded vote is so ordered. The clerk will call the roll.
Mrs. Maloney.
Mrs. Maloney votes aye.
Mrs. Maloney votes aye. Ms. Velázquez.
Velázquez votes no. Aye.
Ms. Velázquez votes aye. Mr. Sherman.
Sherman votes aye.
Mr. Sherman votes aye. Mr. Meeks.
Meeks votes aye.
Mr. Meeks votes aye. Mr. Scott. Mr. Scott votes aye. Mr. Green.
Green votes yea.
Mr. Green votes aye. Mr. Cleaver.
Aye.
Mr. Cleaver votes aye. Mr. Palmer.
Perlmutter votes aye.
Mr. Palmer votes aye. Mr. Himes.
Himes votes aye.
Mr. Himes votes aye. Mr. Foster.
Foster, aye.
Mr. Foster votes aye. Mrs. Beatty.
Mrs. Beatty votes aye.
Mrs. Beatty votes aye. Mr. Vargas.
Vargas, aye.
Mr. Vargas votes aye. Mr. Gottheimer.
Gottheimer votes aye.
Mr. Gottheimer votes aye. Mr. Gonzalez of Texas.
Gonzalez votes aye.
Mr. Gonzalez votes aye. Mr. Lawson.
Aye.
Mr. Lawson votes aye. Mr. San Nicolas. Mr. San Nicolas. Ms. Axne.
Axne votes aye.
Ms. Axne votes aye. Mr. Casten.
Casten votes aye.
Mr. Casten votes aye. Ms. Presley.
Presley votes aye.
Ms. Presley votes aye. Mr. Torres. Mr. Torres. Mr. Lynch.
Mr. Lynch votes aye.
Mr. Lynch votes aye. Ms. Adams.
Adams votes aye.
Ms. Adams votes aye. Ms. Tlaib.
Tlaib votes yes.
Ms. Tlaib. Ms. Tlaib votes aye. Ms. Dean.
Dean, aye.
Ms. Dean votes aye. Ms. Ocasio-Cortez.
Ocasio-Cortez votes aye.
Ms. Ocasio-Cortez votes aye. Mr. Garcia of Illinois.
Garcia is an aye.
Mr. Garcia votes aye. Ms. Garcia of Texas.
Garcia of Texas votes aye.
Ms. Garcia votes aye. Ms. Williams of Georgia.
Williams of Georgia votes aye.
Ms. Williams votes aye. Mr. Auchincloss.
Auchincloss votes aye.
Mr. Auchincloss votes aye. Mr. McHenry. Mr. McHenry votes no. Mrs. Wagner.
Wagner votes no.
Mrs. Wagner votes no. Mr. Lucas.
Lucas votes no.
Mr. Lucas votes no. Mr. Posey.
No.
Mr. Posey votes no. Mr. Lukemeyer. Mr. Lukemeyer votes no. Mr. Huizinga.
Huizinga, no.
Mr. Huizinga votes no. Mr. Stivers. Mr. Stivers. Mr. Barr.
Barr votes no.
Mr. Barr votes no. Mr. Williams of Texas.
Take your no vote.
Mr. Williams
Okay.
votes no. Mr. Hill. Mr. Hill votes no. Mr. Emmer.
Emmer, no.
Mr. Emmer votes no. Mr. Zeldin.
Zeldin votes no.
Mr. Zeldin votes no. Mr. Loudermilk.
Loudermilk votes no.
Mr. Loudermilk votes no. Mr. Mooney.
Mooney votes no.
Mr. Mooney votes no. Mr. Davidson.
Davidson votes no.
Mr. Davidson votes no. Mr. Budd.
Bud votes no.
Mr. Budd votes no. Mr. Kustoff.
No.
Mr. Kustoff votes no. Mr. Hollingsworth.
Hollingsworth votes no.
Mr. Hollingsworth votes no. Mr. Gonzalez of Ohio.
Gonzalez votes no.
Mr. Gonzalez votes no. Mr. Rose.
Rose votes no.
Mr. Rose votes no. Mr. Stile.
Style votes no.
Mr. Stile votes no. Mr. Gooden.
Mr. Gooden votes no.
Mr. Gooden votes no. Mr. Timmons.
Timmons votes no.
Mr. Timmons votes no. Mr. Taylor. Mr. Taylor votes no. Madam Chair.
Yes.
The chair votes aye. I will now go over the members that were missed in the original order. Mr. San Nicolas. Mr. Torres. Mr. Stivers. And that concludes the roll call for that vote.
Based on the roll call, it appears all members who are present have voted. Does any member wish to change his or her vote? If not, the clerk will report.
With that vote, Madam Chair, we have 28 ayes and 23 noes.
A majority having voted in favor, H.R. 3007 as amended is reported favorably to the House. Without objection, staff are authorized to make technical and conforming amendments to the measures under consideration. Ladies and gentlemen, this concludes the markup. I thank all the members, and this meeting is adjourned.